Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dahil hindi Anglican for each service Latino. I didn't ask you to interrupt me.
Literally not.
All right. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Great comments here. Woohoo. Hang on. Let me first, actually I can do this right here. Okay, on, boom. Woohoo, we get RA 3 times today. Great comment. And then also this one, OMG, Adam is in charge of the internet. Adam Nusky, like Husky, my good friend. Yes, you won again, or you lost again, or you were caught again red-handed. One of the 3 things happened. We have a repeat offender. Adam has won the internet, I believe, if I check the record, 10 or 11 times before. Adam, is that right? 10 or 11 times? Does that sound like your rap sheet? But welcome back again. You've got a 2 for now. 2 out of 3 times today you won the internet. Congratulations, my friend. All the internet is yours to maintain and take care of. For our benefit, not for your. You can use it as well, but only in like testing capacities. All right. That said, we are getting ready to go back to Thurston County District Court number 4 for part 3 and possibly the final part of today's just crazy trial involving a First Amendment auditor being charged with assault for an altercation that may allegedly occurred when he was filming inside the DSH building in Washington. I think it's DSHS. Is that it? That being said, I also have to say that somebody who was it said this. Let's see. When I was late, because I was late, that I was probably dealing with the inspector. Name that movie. I got a D-. I passed. I got a D-. We passed the inspection. It took all of 5 minutes. Same dude that came out last time and gave us all the no things, said yes to everything. And you know what his comment was? He's like, normally when I give people a list of things to fix, it takes 3 months for them to fix. You guys did it in a week. So it's like, yeah, that's because we're, a dollar waiting on a dime here. Anyway, so we have, we passed. The Airbnb passed. Now we're going to go out and sleep in it and see if it actually works. So anyway, it's huge. It's amazing. We're going to start taking some pictures. It looks, it's not huge. Actually, it's small. It's a huge thing for us. It's a very small Airbnb. It's about 800 square feet. We're excited. We've got all our cabinet faces on. We've got, the lights. We've got like little tiny things to fix. Like there's a little bit of drywall where we had to punch a hole because the electrical guy said we had to. So we've got to fix that. We have a lampshade that we need to replace because it broke. That's pretty much it. I think we're going to replace the washer and dryer in there. We're looking at another one. We might be bringing a different one in that we like better. Other than that, the rugs are in place. The couch is there. All the little soft, little felt sliders are on the bottom of the furniture. It's beautiful. TV's on the wall. Internet's working. What more could you ask? So we're going to go out there and stay there, and then we're going to go list it and see if we can't put somebody in it and get them to pay us for the privilege. And that's it. That's all. Okay. Let's see. Mary Murphy says, "My home for my home. I love this community. Thank you mods, chat, and Scott for making this place so beautiful." Thank you very much, Mary Murphy. Appreciate that. Wonderful to have you here. Would not be the same without you, Mary. Thank you so much. Let's see. Diane says, "RA, I want you to know some of us here in Thurston County drink filtered water here, so we're not as loony as some people out here. Not going to point any fingers. But this case has been amazing. I was telling Mrs. R.A., who's been focusing on school all day, she hasn't followed the case at all. I was telling her, this case is bizarre. We've already got a lawyer who admits she made a mistake in the jury selection. And kicked off the wrong person. Probably won't make a difference. We've got it's an interesting set of facts about the case itself. You know, you don't have many of these First Amendment auditors. They're a smaller group of people. Typically, they're not as common, so that alone makes it quite interesting. We've got a judge who seems to be, I would say, distracted, defending his own position, and thus possibly made some, in my mind, questionable rulings while he was busy researching, supporting his argument for something which I think he did wrong initially. Just lots of fun things. We've got a brand new, it looks like rookie prosecutors operating with the help of their boss and the prompting of their boss. We have a defense attorney who is good, but very deliberate in most things she does. Sometimes she gets lost halfway through the question. But just a crazy case. We watched
someone with more experience.
Of course, send someone with more experience next time. Yeah, it's crazy to watch this and see it unfold. It should be done today. We're expecting that there's only one more witness, and this witness is probably going to be the individual that, oh no, brandy raid. There's a brandy raid coming back. All right, wonderful. Somebody spoil it for me. What did Alex Murdaugh get? I know he's already serving life, but what was the sentence he got? But anyway, yeah, it's definitely not the same caliber of trial as far as professional experience than we saw in the Maya trial. 27 years.
Alex stole it as well.
27 years on top of life, right? Wow. Okay. He has to serve 85% of 27 years. Let's see. Parrot Court, bus stop juror number 69. Please take your seat. Reserved member seat on the front row. Your bus stop juror, I see you. On top of 2 life sentences. So, yeah.
I object.
I object as well. Anyway, we're gonna keep an eye on court because that's going to start here in moments. I think within about 5 minutes we should expect a live stream, and then it will just be going. And so yes, so we are watching a trial out of Thurston County, Washington. This is a
Send someone with more experience.
That's Mr. Farag, who is also in Thurston County, Washington. He was supposed to be in court previously on Monday, but last week when he was also in court on a different charge, he stayed for half of his trial and then left at lunch and never returned. So there's a bench warrant out for his arrest. They're looking for him and his 3 dogs. And because that's,
when are we
they're
going to
always
break for lunch, Judge?
Well, we just broke for lunch. But he left at lunch. That was his voice, by the way. He's an interesting person. He's a pro se defendant, and that's where we first found this court. And now we've got the second follow-up case, which is, went back to back with what Mr. Farag's was supposed to be. Yes, he is still on the run. Mr. Farag is still on the run. We have not seen him arrested yet. We keep watching the docket in the jail in Thurston County to see if he shows up. So far, no luck. But we'll keep an eye out for him because he has to buy dog food eventually. They're going to get him. I think the dogs will be his downfall, really, because he can't just keep them inside. He's going to have to walk them. He's going to have to, they're going to find him. We have had so much craziness. We've had absurd rulings from the judge. I'll say that now. I can say that because I'm not a lawyer, okay? We've had absurd rulings from the judge on what he sustains and what he overrules. We've had overzealous witnesses, one in particular, who has so much to say about everything, including things he didn't directly witness, and just a fun little jury, with one juror who's just so excited to be there. Hopefully juror number 7 ends up being the foreman, and he gets to frame his certificate of service and everything. It's going to be great. Brandy viewers need to know about Mr. Farag. Mr. Farag was how we first found this court. Mr. Farag is, he is just now, they're trying to schedule trial dates for traffic tickets he received 2 or 3 years ago. Okay, this is how long he draws out the process, and he is a pro se guy that does all his own stuff. He is, he's a piece of work. He really is, and he loves his lunch, and doesn't want to miss his lunch, and he also loves his dogs. Anyway, so we're getting started to go back in court where Mr. Was it Ferre? Now I can't remember the gentleman we're following right now. It'll come to me. Anyway, Mr. Farag and Mr. Ferry. Mr. Ferry is Farley. Mr. Farley is the guy who goes around filming in public places saying, you can't kick me out. I have my right to be here. It's First Amendment. This is a public space. I can film. I can do whatever you want. No. I can be right in your face. You can't stop me. You can't touch my camera. Well, guess what? An altercation occurred after one of these events. He has his YouTube channel. It's called Pacific Northwest Transparency. It's got 9,140 roughly subscribers, so some people are watching him. And he makes these videos. He's made 91 videos so far, including a couple about this very case. But he was charged with assault for one of these events, and now we're in trial for that. And we have a rookie prosecutor and an interesting defense attorney, and that's all. Check now. Let's see. Who says check now? I just checked now. It's not going quite yet, but it's 30 seconds. We should start. Okay. We also have, I'm not sure, Ozzie Gardner, whose birthday it is today, and as you can assume is probably residing in Australia. Ozzie Gardner, who we sang to this morning, after hearing about this case, went on YouTube and went to the Pacific Northwest Transparency channel and said, hey, saw you were in court. Get interesting content. I'll give you a sub. I'll give it a shot. The defendant, over the break, read his YouTube messages, took it to his lawyer, and said, look, lawyer, one of the jurors, must be a juror because they're the only people who've seen me in court, one of the jurors has just subscribed to my channel, and their username is Ozzie Gardner. So we had that as well. So Ozzie Gardner, congratulations, he made it into the court record. It just has a little bit of everything in this trial. So right now we are at the tail end of the prosecution's case. We don't expect any witnesses on defense, and then it will go over to to defense and closing statements, which are going to be interesting because the arguments are they're arguing the camera thing, but he's charged with assault, and so far very little has been said about the assault. Okay, still not live. We're refreshing every couple seconds. Who are the Broken Bakers they raided? Broken Bakers. I don't know. Broken Bakers, welcome. I'm not familiar with your channel host. Or if I am, I don't remember. Broken Baker. I have to look this up. Now I'm intrigued, curious. Gets curiouser and curiouser as the moments go on. Okay. I might know them and not remember. Part of the problem is you have two B's in your name, and my keyboard does not like typing the letter B. There we go. Broken Baker, mostly covering politics in Denmark. But everything goes. I see you, Broken Baker. I see you. Welcome from Denmark. Let me see. At a former baker, there will be cake sometimes. There will be cake. That is awesome. Crime, bacon, and politics all mixed into one. Broken Baker, thank you very much. I'm gonna click the subscribe button there and give that a watch. I can't wait to check out.
When are we gonna break for lunch?
Soon. Looks like you've got some interesting cases you followed, so I'll give that a view. Thank you very much, and appreciate the raid, of course. All right, checking on court one more time. Still no live stream quite yet. It's coming soon. So Ozzie Gardner is probably asleep right now and has no idea. They were singled out in this case by the defense, who clearly assumed that Ozzie Gardner must be one of the 6 jurors in the courtroom, as if no one on the internet, and the judge says, there's no media watching this trial. Nobody's watching this. So he thinks. Anyway, thanks for subbing. You are welcome. Feral Housewife, love that name as well, by the way. We have some great people with great names here. Broken Baker is a YouTube streamer from Denmark that streams True Crime Trials 2. That is awesome. I will give it a follow and check it out. And the more the merrier. We talk food often. Food is always appropriate. It's never irrelevant. Speaking of food, I bought a pomegranate. I slipped a pomegranate into the grocery the shopping cart without my wife noticing. It's the first pomegranate I think we've purchased since we got married. But I slid it in there, and then it showed up in the fridge, and she was like, why do we have a pomegranate? And so I opened it today and ate a couple seeds. I don't know what else you do with it, but you put the seeds in your mouth, and you realize immediately that there's more seed than anything else. But they taste good. I guess this is super fruit. So thank you, Eileen, for subscribing to The Broken Baker. Appreciate that. Let us know what you see if you're able to watch before I'm able to. That would be great. You put it on a salad. What do you do with the seeds, Jen? Are you supposed to peel them? Like, I mean, you take the husk off, right? Like the orange peel. And then you have all the pulp and the seeds. But inside the seeds, you have inside the fruit, you have more seeds. How do you don't crunch those, do you? I think I'd like chip a tooth or something. Anyway, you eat it all. The whole thing. Just like an apple. Don't peel or anything. Pomegranate seeds mixed with apples, raisins, and Cool Whip. You eat the seeds. It's food for OCD peeps. Okay, I'm curious about this. Is it honestly something that's supposed to be helpful for people with OCD? Brandy, welcome. Brandy, you poor girl. Are you feeling okay? I realize you're on the mend and hopefully feeling a little better than you were before. But man, you're working an extra shift there with Alex Murdaugh and the financial crimes. That is that's tough duty. Still no live stream from Thurston, so we're waiting here. You eat the crunchy bits. I was told to my kids you're supposed to spit them out, but maybe that's where the good stuff is. Brandy, if you weren't aware, Brandy watched or followed the Alex Murdaugh hearing today and the sentencing, I guess, and in that all those financial crimes. If you need to go back and watch that, highly recommend you check out her channel for great commentary and a wonderful community as well at the same time. I think Emily D. Baker was following it as well. Probably going to hear some of the other the people around and adjacent to LawTube covering that. It's a big trial, of course. The seeds are everything. They pop in your mouth. I think I'm going to like split a tooth if I bite one of those seeds. They were like rock hard. Are you supposed to like bake them or something first? It's yummy. I don't eat the seed centers. All right. I have competing evidence about what to do.
When are we going to break for lunch, Judge?
When are we going to break for lunch? Not quite yet. We're waiting for court to begin right now, and they're not live yet. Okay. All right. So this case, like I've said, is absolutely crazy. It has a little bit of everything other than pro se, and
Have them send someone with more experience.
We'll do that next time. It doesn't have pro se and it doesn't have subset, but it has everything else you could possibly imagine, including some spicy moments, angry judge, crazy objections, weird rulings, hilarious witnesses. So we have all of this going down, and we have let's see, how cool, a tech guy won the internet for the afternoon. Yay! Way to go, Adam.
Is that correct?
That's correct. If you eat the seeds too, best part. Is there like flavor in the seeds? The seeds are hard and bitter. Guys, I've never actually bit into a pomegranate seed. Wouldn't it be wild? They call Mr. Frog as a witness, as a character witness against the judge in the defense case. At one point in this case, the prosecution threatened to add an additional charge. They're like one witness away from resting their case, and they're like, we'd like to add an additional charge of filming in a public building. Judge did not allow them to do that, but that would have been crazy. I need somebody else to eat them first and assure me that they're safe. That's all. Also, interestingly, this is a Zoom feed of court, and in the last session, they went to four video mode where you can see 4 pictures, but it's really just the witness and the courtroom doubled. So you get the witness in the courtroom and the witness in the courtroom on top of each other. Ouch, that hurt. I think I just chipped a nail. That hurt really badly. Don't forget the room redesign. Yes, the The lectern has been moved all over the place. It's been dragged out of the room. It's been moved behind the TV. It's been twisted and moved off camera. The lectern has moved everywhere. See, Corporal U.S. Marine Corps retired says, if you eat the seeds, the pomegranate tree will grow in your stomach. I have it on good authority. I know this works with watermelon, and so I tend to believe that. I tend to believe that as well. This is why my kids don't eat healthy food. Okay, we should be back in court, but we are not yet, so we'll keep waiting. Don't want to miss a moment of this. Elizabeth Spencer, thanks for calling in, by the way. Elizabeth, hometown up there not far from Tumwater, which is where this offense allegedly occurred. Let's see. I thought it was only watermelon. Glad you got her ice cream. Me too. Kids deserve ice cream more often than we give it to them, probably. That is awesome. That is just cool. And I'm not sorry, not even one little bit. Does the ballerina trial start tomorrow? I think it's coming up quick. I'll have to double check. Let's see, PJ, when you say did you get the B&B certified, what certification are you referring to? We got the final inspection authorized, and we passed our final inspection from the county, so it is now authorized for habitation. Is that what you're referring to, or is there some outside governing body that certifies Airbnbs? Oh, here's a city calling me. Maybe they're reversing my decision. Hello. All right. It was the inspector saying we're trying to print this off and we've got an error, but we fixed it. Yes, hello, inspector. They just have a million things they want to do. All right. Keep checking court. I promised you guys he was going to come back to court, and now I'm not as sure in my promise because we're almost 15 minutes late for court to start. Is court delayed because Mr. Farley went on the run with Mr. Farag? I would love it if Mr. Farag made a cameo in this one. Purple Haze says, trees growing in stomachs was on my bingo card today. I'm glad we could help you out with that one. They're all in the jury room. They're helping themselves to the free water. No surprise about the lateness. I was late as well, so I really don't have grounds to complain today. I've been late. This is what happens when you hang out with Rob too much. Rob, great guy, great friend of the channel. As he says, time is a construct, right? And I've taken a more liberal view of time. Since I've started listening to him more closely on some of his opinions. You know, what's a few hours between friends, really? This is a call the clerk moment. We have to first check and see what the state, to see if they are a one-party consent state. Because if it's a call the clerk moment, I need to make sure I can actually air it without saying I need their permission. Because so many people are hesitant to talk when I say, and by the way, you're live on the air.
Bring the jury.
Rob will be on 8-ish. Rob will be on tonight, and I'm super excited because Rob, I think he has some great stuff. I'm not gonna spoil what he has announced or what he has prepared, but he has some great information to share, and I'm super excited for him to be able to share it tonight. Who was the auditor? The auditor here, and this is Mr. Farley. Mr. Farley is the auditor. We're just waiting for the Thurston County District Court Zoom to go live again, which it's not yet. Washington is a two-party consent. Oh, that's no good, Teddy Bear. Teddy Bear, this is the wrong answer. We need one-party consent because then I can just put it on the air without telling them. You get such better content that way. Now, here's the question.
Alex stole it as well.
Do they have subject matter jurisdiction on this? Because I'm not committing a crime in their state. And do they have authority to reach over state boundaries and convict me of a crime I committed in another state that's not illegal where I am? Huh? Can we talk about subject matter jurisdiction on that one? Exactly what does auditor mean? It's a loose term that they've appropriated. It basically means someone who performs a check to see if you're in compliance.
There's a lawsuit.
There's a lawsuit. Let's see. Sleep, what is that? It's overrated, whatever it is. For those that are curious, and I realize I've told you that we don't decorate for Christmas. I know this is unrelated, but I saw this comment and I thought about it. My kids put up the Christmas tree. By kids, I mean my three youngest kids, the oldest one being 12, set up the entire Christmas tree, all the decorations, and all the lights. Courtney Meek says, I have PTO to burn before the end of the year, so I took off tomorrow. I get to watch you in the morning on my big TV. You've got use or lose PTO, Courtney. That's both a curse and a blessing because you end up taking it at a time when you don't want to go anywhere because it's too cold. Come on, Thurston. Where are you at? Why are we not live yet? We've got, it's 4:30, so it's been 15 minutes. It ignored you and wouldn't let you sit. It's working. Some of them are working. SW Record 75 is admitted to being an addict. That's what happens when you click the subscribe button. Welcome, SW. Good to have you here amongst friends. You can never leave now, just FYI. You've got a new sectional couch to watch big screen TV. Ashley, that is awesome. That is awesome. I'm glad I'm not, because look, there's just too much of me when it's this big on a big screen. Plus, I'm not in focus, which was even worse. There's a pretty good focus. It's close enough. There's just too much of me there. Okay. I'm nervous. Do we call the court? Elizabeth, we might need to have to send you down to the court to make sure they're live streaming. Red Pen says, I'm so embarrassed to realize that I appeared on people's giant TVs when I appeared on RA's Not Relevant podcast. Yes. Giant TVs. There were like 80-inch big screens, projection TVs, stadiums on the replay machines were watching you, Red Pen. Lots of people. The defendant bailed. This is, if they have 2 for 2 on the defendant skipping out on court, this would be hilarious. Red Pen was great, as was Adam Nusky. We need to do that some more. We have a situation, by the way, this week. We are supposed to have a podcast on Thursday. Well, I haven't brought this up to Weather Watch yet. Apparently, our town is also doing a Christmas parade on Thursday. The only problem is I am live streaming the Christmas parade for the town on the town's channel, so it won't be on my channel. And I'm fine with that because they're probably going to play music halfway through from some of these floats, and they'll get a copyright strike, and the town's channel is going to get banned. But I don't want that to happen on my channel. But I need to figure out how to do the podcast. It's probably going to be just on a StreamYard on a laptop or something. So no backdrop. But okay, Iris D says, "What's this case?" We are following a case. Actually, it looks like this one right here. If you haven't watched, Thurston County District Court number 4 has a case. It looks like there are 4 videos, but there's really only 2 that were part of the day. These last 2. This is a case of somebody who's been filming, and I keep just refreshing to see if another window pops up. But they were filming in public. This one, Weather Watch. but I need to know when the parade is, because the parade's, it can be like between 4 and 9. So it might not even be a conflict. It might be done before anything happens, and then we'll be fine. I think that's going to happen. Anyway, we skipped the podcast last week because of the Thanksgiving holiday. Oh, come on. Where's the video? We have nothing. You all right? What's up?
Mom wants to know what that Prime Video is, because we can't sign it to the TV. Not necessary.
Tell her, does she need the pin?
Yeah.
Hey, Jen, come here. I put a pin on my new TVs just so that the kids wouldn't use them nonstop to watch cartoons. And now I can't remember what the pin is. The pin is... Oh, wait. It's got a weird shift button to... And don't let the kids watch you because they're smart and they'll learn it. All right. Okay, that's it. We're calling Thurston County. Hey Siri, call Thurston County Courts.
Calling Thurston County Family and Juvenile.
No, not Family and Juvenile. No. Stop. Whoa. Hey Siri, call Thurston County District Court.
Which one?
It says permanently closed. Courthouse.
Sorry, I didn't quite catch that. Could you please say that again? Here's what I found.
Okay. Dang it, Siri. You know what's going to happen? As soon as I start calling, it's going to just pop up on the live stream. Okay, here we go. Let's do a quick Google. Thurston County, Washington. Court clerk. There's a buffer sound. I'm on. Amber says I'm already on hold with the clerk's office. There we go. So this is why we have amazing mods, you guys. Literally, without prompting, Amber just jumps on it. Ohio Palm Mom says, getting caught up after Emily D. Baker live. I'm glad you guys got to catch up and watch the sentencing. You got
Making him watch Holiday Inn.
You're making him watch. You mean mom. All right. Let's see. I wonder if they're just... The judge got out on YouTube. Is this what's happened? Okay. Let's see. Joy says, oh my gosh, I got a new phone yesterday and I've never had Siri. She just tried to call Thurston County Courts. Well, it's a good thing I didn't have her order a bunch of things off Amazon, right? So, trust your mods. We have the best mods here. The live feed is a good thing. I don't think they cut us off. What's the other Baker channel? The Baker channel, Broken Baker, is that what it was? Yeah, I know there was alliteration. Broken Baker. Just whatever you do, Amber, don't tell them that we're watching, because then they change what they do. Leanne Hokulani says, took me 2 weeks to rewatch the Kowalski trial. 2 weeks. You binge watched the whole thing. That is amazing, because it took 9 weeks for us to watch it originally. That is cool. Did you watch it on high speed? All their folks are currently assisting other callers, but the hold music is decent. Muzak. RA, this is my life. When we plan always, then 30 minutes ahead. Yep. Still nothing. I'm gonna check the other. Let's see. There are 3 other courts. Let's see. Live. Hour ago, Thurston County District Court. That's the state interpreter calendar. That's not the one. Let's go back to District Court 2. is live right now.
When are we going to break for
Today,
lunch, Judge?
Mr. Taylor indicated that he missed court.
That's our fun judge.
Because he didn't know about his court date.
That's the wrong guy,
He has
though.
an extremely limited criminal history, no convictions on his.
So that's not the one. I mean, that's the right. He's the guy, the judge that handled the Farag case. Live, nothing here. Okay. Watch it on 2 times speed and put all the timestamps in comments. Oh my goodness. I just drew the connection. Okay, you guys, can we stop just for a minute?
Because he's the guy.
Leanne watched all of the Maya trial and went back and literally, I saw these comments as they came in. Every single time she finished the video, she put timestamps for every different event that happened during the trial. So I can now take those timestamps and put them in the description, and it will have bookmarks for everybody on this. Leanne, that is amazing. That is huge. I cannot thank you enough. First of all, I have zero patience to be able to do that myself, or organizational skills. And you went through and did that in a couple of weeks, put the timestamps on everything. Thank you so much. I saw those coming in. They're phenomenal. This allows people who want to go back and rewatch or find just a certain witness on a certain day to just jump right to it. It helps the channel immensely. I cannot thank you enough. That is incredible. Thank you, thank you, thank you, thank you. Let's see. Send that girl a hoodie. Leanne, can you reach out to me on the burner phone really quickly? I would like to just you don't have to call. Just send me a text message on the burner if you can. But that was just amazing. Okay, hang on. What's happening here? Whoa. Canceled. Why was Manatee canceled? Why was the ballerina thing canceled? Does anybody know? Yes, major props to Leanne Hokalani. I think I'm saying your name right. Adam, by the way, you did a great job owning the internet before. I'm going to unpin your message. We just expect you to keep doing a good job today as well. All right, let's see. Oh, they just went live just now. Just went live. Here we go.
Now that I want to make sure it's clear from the city's perspective.
Go ahead.
The city has not received any discovery and want a standing objection to any attempt to introduce any further evidence from defense unless it was provided by the state to defense counsel. I'm not aware of any other exhibits Ms. Rowe intends to introduce, but my concern is that in an attempt to introduce exhibits in front of the jury that have not been provided to the state, or excuse me, the city,
How does he do
the
that?
jury would interpret us attempting to suppress or hide information that they wish to see.
Well, do you have any more exhibits you wish to have introduced, Ms. Rowe?
No, I don't.
Great.
Thank you.
That resolves that. And now I'll just, what instruction were you talking about? Ms. Rowe, did you say you have a proposed instruction you want to?
I was trying to get the instruction regarding
self-defense. Say self-defense.
Defense of property. I still,
okay, that works.
I'll need to review it. The copy I was able to retrieve is not in the WIPIC and jury pattern instruction form that I usually present. So I'm still going to be reviewing it, but that was the one.
Your Honor, the state would object. We've been given no notice to any sort of defense of self-defense or defense of property defense that defendant intended to pursue. A motion in limine was granted. The defense had no objection to our motion in limine regarding that, and has never provided the state notice.
Well, we're going to take the next witness. We'll hear the defense case, and then we'll talk about jury instructions after that.
Thank you, Your Honor.
And we'll deal with it then.
Lindsay,
we'll bring the jury back in.
It's not so much that I'm not able to; it's that I don't have the organizational skills to track and and stay on task to do them.
Bring the jury.
Okay, why is it double? This is just a feature of the court, which just honestly, it's par for the course today. This is how it appears on the court feed if you were to watch directly from the Thurston County District Court Room number 4. That's just the clerk who's running the Zoom built it this way. So.
Be seated in the courtroom. And then Fortunato may call his next witness. I know that he's being brought into the courtroom. First of all, I just want to say I apologize for the delay in getting started. I'm notoriously bad at predicting how long breaks are going to be, so I'm sorry about that. My responsibility to make sure the courtroom runs on time and we're not late. So if you're looking around for someone to be irritated with, you could be irritated with me. So I apologize for the delay.
Judge, falling on the
Your
sword
Honor.
there.
The state would next like to call its third and final witness, Mr. Randy Rainey.
This is going to be the security
For
guard.
the city, rather.
The city. He doesn't know who he's representing. Okay, so the gentleman on the far left of the image over there, that side,
Raise your right hand, please.
is accused of
You swear
assaulting the guy who's
information
about to sit on the stand, I
testimony
think.
you provide will be the truth, the whole truth, and nothing but the truth? I do, sir. You can be seated.
So now we're finally to the crux of the matter.
Mr. Fortunato, you may inquire.
Thank you, Your Honor. Good afternoon. Would you mind stating your name for the record?
Ken Rainey,
And could you spell that for us?
last name Rainey, Raney.
Thank you. Where do you live, Mr. Rainey?
Say again?
Where do you live?
In Lacey, Washington.
And what is your occupation?
I am a security officer,
And who do you work for as a security officer?
Pierce County Security.
Okay. How long have you worked as a security guard for Pierce County Security?
About 12 years.
What is your primary responsibility as a security guard?
To hold security in the area itself and protect the personnel that are there.
How important are facility rules in this job responsibility?
Very important. Very important.
How often have you worked at the DSHS location in Tumwater?
I've worked there almost 3 years.
Do you remember if you were working on the afternoon of July 20th, 2023?
Yes, I was.
And where is that DSHS located?
6860. What was it? Southwest.
Is that in the city of Tumwater?
It's Boulevard. It's
Okay.
Boulevard Southwest.
Okay, and that's in the city of Tumwater?
Yes.
And that's in Thurston County?
Yes.
And that's in the state of Washington?
Yes, it is.
What hours is the DSHS office located or open rather?
From 8 o'clock in the morning till 5 in the evening.
What do people come to the DSHS office for?
They come for services for food and medical services, along with monies also for the family food.
Could you briefly describe kind of the layout of the DSHS office?
It's rectangular office. The lobby is itself. We see approximately 30 people in there.
Okay.
We do have a TV on for the children to watch also if they're in there, keeps them quiet.
Oh, TV for the kids.
We have 2 personnel that are called navigators. When the people check in, they check in with them. And during the day, the office itself in the back and also on the side of the lobby, that's where they hold interviews at for the food substance or whatever.
Is recording allowed in the DSHS office?
No, it isn't.
And why is that?
It's private office, in the office itself. The lobby, though, they can video.
And by lobby, do you mean the lobby of, or what do you mean by in the lobby they can record?
Where all the people are sitting at, waiting to be seen.
That recording is allowed in that area? Where specifically is recording not allowed?
Is allowed.
And on the side of the lobby, there's a barrier, a small partition wall. It has signs on it saying no recording, no audio or video recording. That's where they do the interviews at.
And how are patrons made aware of this rule?
There's signs up. For that?
Of this rule, yeah.
Rule. You can talk to the personnel in there, in the office itself, that has the rule. It's not actually posted on the outside, but there are rules for your behavior while in the DSHS.
And you said there are signs that say that recording is prohibited in this location?
In that one area, yes.
And if you were to see this sign, would you be able to recognize it?
Yes.
Here's the sign, guys. Here's your sign. We brought the sign.
Your Honor, I'm showing defense what's been marked as a State's Exhibit 1.
Final witness,
Your Honor,
first
permission
exhibit.
to approach the witness? You may.
Permission to approach.
Let the record reflect that I am showing the witness what's been marked as State's Exhibit 1 for identification purposes.
For a minute, we had him on all four
Mr.
screens.
Rainey, do you recognize this photo or what's within this photo?
It's right behind my desk at the in the lobby.
It's right behind your desk in the lobby.
Yes.
Is it fair and accurate depiction of what the DSHS office looks like on July 20th, 2023?
Yes.
Your Honor, I move to publish Exhibit 1.
Any objection? Are you asking to admit it?
Yes. Yes.
Any
No objection, Your Honor.
Okay. You may publish.
May I
it.
approach?
You may.
And you said, Mr. Rainey, where is this sign located within the DSHS
One
office?
right behind my desk, which is that one there. There's also another one on the bookshelf to the left of that. And down on the partition further down is on the a pillar, square pillar up there. It's on that and on the partition wall also.
And you said that this rule is in place in the office.
Yes.
It's specifically with certain areas within the office. There is no audio or video recording. Could you explain why this rule is in place?
For privacy.
For privacy of who exactly?
The client and the worker itself.
Mm-hmm.
They interact with information back and forth to prepare for themselves for the benefits and stuff.
Thank you.
Yes.
Or they're about to show a video just off screen. Look, they're prepping. We're not going to see the video. Please,
Mr.
Judge,
Rainey,
turn the
was
camera.
everyone following this rule on July 20th, 2023?
Yes.
Not
Everybody
not
was following that
everyone.
rule?
Yes.
Did anyone enter the facility with a video recording device that day?
Yes, they did.
Someone did. Is that person in the courtroom today?
Yes.
Would you be able to point them out by describing an article of clothing that they're wearing?
They got the boots on, heavy boots, I guess.
In your honor,
one thing we
may the
can't see.
record reflect that Mr. Rainey is pointing to Mr. Jeremiah Farley?
He didn't point at all.
It will.
His hands stayed clasped together in front of him. The record shall not reflect anything of the
One moment.
like. His chin may have indicated in his general direction, Did I miss something? Sorry, we need to
So
back
Mr.
up.
Farley
Wait.
out by the courtroom today.
Yes.
Would you be able to point them out by describing an article of clothing that they're wearing?
They got the boots on, heavy boots, I guess.
In your honor, may the record reflect that Mr. Rainey is pointing to Mr. Jeremiah Farley?
It didn't happen.
It will.
Didn't happen. In his mind, he was pointing. We have psychic prosecutors. This is a weird trial. Oh my goodness.
So Mr. Farley entered the DSHS office that day. Did he mention to you why he was there?
If you type exclamation point address, it'll work.
Was he made aware of this no recording rule of the office?
Not in that area where I was at with him.
Did he eventually become aware of this rule?
Yes.
Did he abide by that rule once he was made aware of it?
No.
What did he do after being advised of that rule regarding video and audio communication or recording?
Well, during that time period, the supervisor was talking to him at the time when he was in that area that wasn't supposed to be recorded. And I let the supervisor know, and
so
he was talking to him.
You said he walked in and he was made aware of the rule regarding no recording.
Mm-hmm.
What happened after that, after he had walked in and learned of that rule?
I confronted him at the doorway and told him people didn't want to be recorded here. And also that I asked him if he could leave the building, and he didn't say nothing, and that's when he hit me.
Did he say that he had an appointment that day?
No.
Was his recording device still running?
I think it was, yeah. I wasn't recording. I wasn't watching the recording, but he had it mounted on to where he could have it in his hand.
Where did this interaction take place within the office?
At one of the doors from the main lobby into the CSO lobby itself.
And as you entered into that lobby itself, was this where the signs were located regarding?
It's off to the side, yes.
Mm-hmm.
Is this where the signs were located?
Or Mr. Farley was already aware of the rule regarding recording in that area?
As far as I know, yes, he was.
Okay.
Oh my goodness.
Were other individuals present within that area at that time?
There was a lot of people in the lobby. The lobby was full.
And by that, about how many, if you had to guess?
35 to 40. It was actually over full. Yeah, a lot of people standing.
Did any of those individuals appear to be recording within the office?
Not that I know of.
So you said he struck you. Would you mind going into a little bit of detail about what that involved?
Okay. As I was confronting him at the door and telling him, if he could leave the building, and that's when he struck me on the left cheek down toward the lip. And I stumbled back and I let him in. And that's when the other guard had notified the duress call on the radio, which got a couple supervisors out and called 911.
So you must have been pretty close to him if he was able to strike you. What were you doing that close to him?
I was talking to him in a quiet manner.
Did he still have the recording device out at that time?
He did.
And did you have any reaction to that recording device being out and present?
Well, I went to block the view of the camera itself. That's when he struck me.
Was there only one recording device?
I think there was only one. I don't know. He may have had a chest one on. I don't know if it was running or not.
Do you remember making contact with his person as you reached towards his device?
I don't know. I was grabbing up toward the camera itself.
And why were you doing this?
To block the view of the camera. people don't want to be videoed in that.
What was Mr. Farley's response to you reaching towards that camera?
He hit me
Where did he hit you again?
in the left cheek and the lip.
And how many times?
It hit me hard and fast, and then some was back.
And you said it was fairly hard. If you had to guess or had to put it into
It
words.
wasn't really hard, but
What
it was
percentage?
enough to jar me off.
Okay.
About a 50% hit.
Did it appear that the striking was intentional?
Yeah.
How so?
He wanted to do what he wanted to do in there. He didn't care about me.
Did he say anything at that point while he was continuing into the room and moving and eventually struck you? Was he saying at that point?
I don't know what he was saying. I stepped back, and my guard had already let the rest know, and also a 911 call. The supervisors were out there pretty fast to talk to him.
Were other patrons present at the time that he struck you?
Yes.
And what was their reactions to this?
There was a lot of commotion. The lobby was quiet until that happened, and there was a lot of commotion going on out there.
Did you remain near Mr. Farley as close as you were after he struck you?
No. I kept the distance from him.
Did anyone come to intervene in that situation afterwards?
The supervisor was talking to him.
And what did you do after that?
I just kept back a distance from him.
If you were to see a video that documented the footage of this incident, would you recognize it?
Probably.
Would that help you remember some of the facts? Or would maybe his facts are accurate and the previous witness was just way off?
Seems we might be experiencing some technical difficulties, but we are, the city's going to be moving to show Exhibit 2, or what's been marked as City's Exhibit 2, to the witness and to the jury.
And Ms. Rowe?
But not
I
to
have
us.
no objection.
Okay. And so do you need a minute? We can break for a minute if you need to set that up.
Okay, I can tell you that this video.
I'm not the best at technology either, but I do know some people who are, so we can call those people in if we need to.
Judge, I'm busy right now.
And Your Honor, it appears that we are ready to go with this recording.
Please, Ms. Rowe, can you just have them move it so we can see it as well? That would be the best. We get audio only, and it might be choice. Just warning, there might be some language on here. Yeah, Adam, good job. You fixed it that quick. We get no audio. We get no video. There's something happening in the...
Actually, if you would hardly refrain from doing that because we have privacy.
Is it a public lobby?
No, it's not.
It's not a public lobby.
Not a public lobby, okay?
Is it?
This is the beginning.
Calm down. Step back. We didn't really close the man.
I'll take a picture while you're in here.
I'm going to gather content for a story.
What's that the case for? This is the business.
Put your hands on me.
You know what? Fuck away from me, I said. So, Washington is a stand-your-ground state. I have every right to defend myself when confronted. I sure is, didn't I? Yes, I did. Yes, the position I never did. How would you know? You never even asked me. I did. Never even stopped anything. Yes, I did. Get out of my way. See? Any way of driving which one's your fucking ass? Get away from me. You tell me if I will defend myself if you get in my face. Put hands on me first.
We're asked to leave. Go.
Bill, who are you?
You were asked to leave. Leave the building.
Leave the building now. Leave the building. I have business to conduct. Step in, Wesley. Step in. Your job is over there. Your job is to observe and reflect. Listen, sir, the second you make your hand on, what I said. You see this? That. Can't do it back here, sir. It's a public lobby. It's a public lobby. Okay. I'm not gonna raise my voice anymore, so you can tell this early. I mean, my own business. I mean, my business. Public lobby. So, sir. Public lobby. I defended myself and he grabbed me. You are security guard. You have a cuff. Back up. Stop.
That's the end, thankfully. I can tell you this much.
No further questions, Your Honor.
Mr. Farley is going
Ms. Rowe,
to
you may
subpoena that
Thank
copy
you.
and post it on his website, on his YouTube.
Good afternoon, Mr. Rainey. Thank you for being here this afternoon. So, Mr. Rainey, I want to talk a little bit about your role as a security guard. You indicated that you have been a security guard with Pierce County Security for about 12 years. Is that correct?
Yes, ma'am.
Are you still employed by them?
Yes, ma'am.
And you indicated that you worked at DSHS for about 3 years.
Yes, ma'am.
Do you still work there?
Yes, ma'am.
And you're still doing security duties for the
Yes.
DSHS office?
Yes.
And what's your schedule there?
I work there 4 days a week.
What time can I come by and see you in action and film you?
And what's your schedule? What are your hours?
7:30 to 5:30, Monday, Tuesday, and Wednesday. Thursday is from 8 o'clock to 5:30.
And he gets a long weekend.
And who is your direct supervisor?
My direct supervisor is Ron Hall.
These are something you should ask in deposition so you can subpoena the right people for your defense. What good does that do now, the day of trial, to find out who his supervisor is? That's it. His lawyer quit. She's just up and done. She's like, I'm sick of this. I'm sick. Oh wait, no, she's back. I'm sick of all this.
As Defense Exhibit 1, 2, and 3.
Pictures of the lobby. It's actually a panoramic, so you can see all around the building. You can stick them together. It makes one big
Do you
picture.
recognize these pictures?
Yes, I do.
And can you identify these pictures?
Yes, this is front entrance to where the guard's at in the CSO lobby. This is the retaining wall between the lobby itself and the interview area.
The half wall right there?
Yes.
And what is this?
This is the front entrance, or the inside entrance from the main lobby itself into the CSO office.
Okay. Now, where did you have first contact with Mr. Farley?
In the main lobby,
And what entrance did he enter?
in front of the building.
So
You
he
gotta
entered
go through
in,
those doors into the main lobby itself.
so he entered into the entrance that's connected to the long hallway.
Yeah.
And where did you first have contact with Mr. Farley?
In the main lobby.
Asked and answered.
And
For the third time,
where
did you first have contact?
Say the scuffling incident between the two of you occurred?
At the door from the main entrance, well, main lobby into the CSO lobby.
So basically in the doorway.
Yeah.
Now,
Let that sink in.
when asked the direct question from Mr. Fortunato, he asked whether or not recording was allowed. Is that correct?
I asked?
Mr.
No.
Fortunato asked you, was recording allowed in the building? And I believe it was your response that there's no recording in the private offices, but in the lobby, you can video.
That's it. Yes.
And then after the state reiterated that question, I believe you testified that recording is allowed in the lobby. Is that correct?
Yes.
Did Mr. Farley make it to the lobby
Yes, he did.
before he was confronted by you?
No.
So you confronted him basically in the threshold doorway
Yes,
before
I did.
he entered the lobby.
Yes, I did.
At any time, did you tell Mr. Farley what areas of the inside office lobby he was allowed to film it? Yes or no?
No, I didn't. At that time.
So he never had a chance to even get to the lobby before the incident between you and he occurred. Is that correct? Yes or no?
Can you say, I'm deaf in this side and 6%.
Okay,
Can you
I'll
say it
talk.
again? I'm
Yes.
sorry.
So Mr. Farley had not even made his way into the lobby,
The main lobby or the CSO lobby?
the CSO lobby.
Okay.
Is that correct?
Yes.
Did you ever specify to Mr. Farley that he could video in the main lobby, but not behind that half wall barrier? Did you ever notify? Pardon?
That subject didn't come up. He didn't ask me a
Did
question.
you notify him? Yes
I
or no?
didn't. I didn't at that time, no.
But that could have been information that you could have shared with him, correct?
Objection, Your Honor.
That could have been information that you
overruled.
could have shared with him. Is that correct?
Yes.
But you didn't. Is that correct?
Not at that time. No, I didn't. Can I? Okay,
If you
thank
would,
you.
I appreciate it. Thank you.
She's like, we got enough from the other witness.
And you indicated in regards to the signage that the sign is posted in one area, which is behind the security desk. Is that correct?
Yes, ma'am.
Now, is the security desk close to the entrance that Mr. Farley entered in?
No, he entered the inner portion of the main lobby itself. He entered in that area, which goes up to the second, third, and fourth floor. That normally before was only an exit. It wasn't an entrance. They've changed it to the outside of the building, which is the entrance.
This is like
So
a
the
maze.
security desk,
Yes.
where one of the signs was posted,
Behind it,
in
yes.
fact, the sign that was shown in the state's exhibit, that sign was posted basically across the room from where Mr. Farley entered. Is
Is
that
at the
correct?
other end of the building, at the other end of the lobby, yes.
At the other end of the lobby.
Mhm.
You also indicated that there were some signs that were also posted on that half retaining or dividing wall. Is
Yes.
that correct?
Yes.
Showing you what's been marked as defense exhibit number 2. Is that half retaining wall the wall that you're referring to?
Yes, it is.
And that retaining wall or that dividing wall is dividing which portions of the office?
The lobby itself and the interview area.
So Mr. Farley could legally video record the lobby area.
Yes.
Did you allow him to do so?
Not at that time, no. Once he shoved me, that was it. I asked him to leave the building.
Once he shoved me.
I'm showing you also, could you point out the signage on the retaining wall?
Here, here, and here.
And those, looks like 2 of those
One on
have
each end.
been marked on this exhibit. Is that
That's one
correct?
right there.
Okay. So 2 of them are marked and one is not, and one was located on the pillar basically
Yes.
connected to that half retaining wall.
And right here beside my desk.
But Mr. Farley hadn't even made it.
No.
Now I'd like to go back to your duties as a security officer. When it comes to situations where a patron does not obey your command, how are you allowed to proceed in those circumstances?
Objection, Your Honor.
Building.
Objection, Your Honor.
Hang on, just stop. Mr. Fortunato.
This is beyond the scope of the direct examination. It also calls for speculation, Your Honor.
This is cross-examination. I'm going to allow again, could you repeat the question?
He wasn't paying attention.
Ms. Rowe, what was your question?
I'm not even remembering it myself.
Clerk, can you read it
Why
back?
don't you ask a question then? And then
Yes,
we'll go
yes.
from there.
Oh, I do remember. When you give an order and somebody does not obey your order, what are the procedures that you, in your security officer duties, what are the procedures? How do you proceed in that scenario?
I can ask them to leave the building.
Hang on just a second. Mr. Fortunato, I'm going to allow him to answer that question. Okay, go ahead.
I can ask them to leave the building and or get my supervisor up there to talk to them, explain what's happening.
Is it part of your duties to confiscate another person's personal property?
No.
Why did you not inform Mr. Farley of the areas that were public spaces where he was allowed to video record?
Didn't come up at the time.
Is it one of your duties as a security guard to inform patrons of that information?
There's signage up.
Did Mr. Farley have the opportunity to see the signage before the incident occurred in the doorway?
No, he
Objection,
didn't.
Your Honor.
I will sustain that objection.
Disregard the fact that he said
This
no, he
witness can't
didn't.
answer as to what another individual did. So, and then I'll strike that answer, and then the jury will disregard that answer. You may continue, Ms. Rowe.
And when Mr. Farley refused to, well, let's back up. Did you see Mr. Farley videotaping inside the lobby?
He had his camera out. He was videotaping in. It was on the whole time. He didn't turn it off.
And while the video was recording and he didn't turn it off, did you notify him at that time of where he could record?
Not when after he hit me. I got away from him right then. Then later, the supervisor that came out and talked to him, I let him know that they were in an area where they couldn't be videotaped.
But that wasn't the public lobby.
No, that was right up to the side there where he went.
So it was the supervisor who notified him that he couldn't film behind that barrier wall.
Objection, hearsay, Your Honor.
So I'm going to overrule the objection, and then I think I heard the answer. As I recall the question, you said, so it was the supervisor, and then the witness said, no, he did. I'm going to allow that answer to stand.
Okay. Did you call for law enforcement to help? Did you follow the protocol that you just testified to that, well, we heard that you asked him to leave. That's correct?
Yes.
And he refused?
Yes.
And did you ever call for a supervisor then?
My partner did with the duress call and called 911.
And who did your partner call for duress?
For duress? Immediate duress call calls for any supervisor available up to the front desk.
Any supervisor of the DSHS office or any supervisor of the security guards?
The office. Supervisor of the office.
So it's the supervisor of the office
Yes.
that you call if a patron does not obey your command?
Yes.
And why do you notify? Why is it the job of the supervisor instead of being your job?
Objection.
That's their protocol, ma'am.
Pardon?
That's their protocol.
And then I'm going to sustain the objection.
It's a little late for that. We
Did
got
the
answer.
supervisor come out?
Yes.
Did the supervisor confirm with Mr. Farley that the lobby was a public space?
Objection, Your Honor. Hearsay and relevance and speculation.
Sustained on hearsay grounds.
Did the supervisor have a communication with Mr. Farley?
Yes, he talked to him.
And while the supervisor was talking to Mr. Farley, was Mr. Farley recording that communication?
I really don't know.
Now, when a patron comes to the DSHS office, is it your or part of your duties to inquire why a person is there?
Why they're there? I help, it's part of my job to help get them to the navigator to get answers. Sometimes they're going up to the.
I'm maybe you didn't not understanding my question. Are your job duties to inquire whether, why, and what a person is doing at the DSHS office?
No, it's not.
Did you ask that question of Mr. Farley? Yes or no?
I assume they had business here.
Was he required to answer you?
Objection, Your Honor. Relevance and speculation.
Sustained.
So even though it's not your job duties, you on this incident asked Mr. Farley why he was there.
Yes.
Did Mr. Farley give you an answer?
Yes, he did.
Is it part of your duties as a security guard for Pierce County security to make decisions as to whether a person's reason for being there are valid or not? Is that your job?
No.
I think she doesn't understand how
And
fast the court clerk can take
if
notes.
a person in response to that question indicates, I'm there for my own business, are there any duties that you are sworn to uphold to follow up on that?
Objection, Your Honor. Relevance.
Sustained.
As part of your role as a security guard, are you given the duty of assessing whether someone else's reasons are valid or not?
Objection, Your Honor. Relevance. Same basis.
Sustained.
Okay, there we go.
Are you allowed, as part of your duties as a security officer, to, and is it part of your contract with DSHS that you are allowed to confiscate personal property?
Objection, Your Honor. This is facts that are not in evidence.
Okay, it's been asked already. and he's given an answer, but I'll allow him to answer it again. Go ahead,
No.
Mr. Rainey. You can answer her question.
No,
And if you want her to repeat that question, she can do that.
please repeat it.
No, I'm not
heard
allowed.
your answer loud and clear, so thank you.
No, I'm not allowed to repeat the question.
Were you required to report this incident that occurred as part of your duties as a security officer?
Yes.
And did you report what happened?
Objection, Your Honor, relevant.
Overruled.
And did you report the incident that occurred that day?
Yes.
Who did you report the incident
I
to?
reported to my supervisor and the supervisor of DSHS.
So you reported it to your supervisor of the security guard?
Yes.
And to the supervisor at the DSHS?
Yes.
In your reporting, did you include the fact that you were attempting to assert some authority over Mr. Farley's cell phone?
Objection, Your Honor. That's facts, not evidence, and it's hearsay.
I'll overrule the objection.
Question, I'm sorry.
Did you, as part of your report to both your supervisor being a security guard and the supervisor at DSHS, that you were attempting to exert control over Mr. Farley's recording
Your Honor, I
device?
have to object again. It's
already
similarly
overruled the objection.
not something he testified to.
He can answer the question.
Okay.
Go ahead.
No.
Thank you.
Why didn't you include that fact?
When trying to take his recording? What was that?
Did you report that you were attempting to exercise control over Mr. Farley's recording device to your supervisor?
Yes. I told him that.
You just said no.
I'm sorry. I'm deaf and I've had 4 strokes in 1 year. I'm sorry. Okay.
And what was your supervisor's response to this report?
To control the video recording, you mean?
Yes. What was your supervisor's response to you telling him you were attempting to exert control over Mr. Farley's recording device? What was his response when you reported that?
I didn't control his recording device. What did he say? Well, you write it down and report what you need to report. I didn't try to grab nothing, control anything.
Did you report to your supervisor that you had not notified Mr. Farley of the public areas where he was allowed to record?
Objection.
Yes or no?
Your Honor, relevance.
I'm going to sustain that objection.
The judge has a coin he's flipping. I swear he has a coin he's flipping. This is my only explanation for why we're getting some sustained and some overruled.
Now, I believe your testimony was that Mr. Farley was not made aware of the rule at first. Is that correct? Yes or no?
It wasn't made of the rule? No.
Cameras, camera recordings of incidents of the lobby at the DSHS office?
No.
No cameras inside the DSHS office? Would it surprise you to learn
Here comes an objection.
that there were cameras there?
Objection, Your Honor.
Okay,
Fact,
I'm
not
going
an evidence.
to sustain the objection. And so, I'll sustain the objection.
I have no idea how this case is going to
Part
end up.
of your duties as a security officer, are you allowed to touch another individual?
No. Unless being attacked.
Wish we could have seen the video. We're going to need 2 more days to cover this trial, apparently, because we didn't anticipate the delays.
During the altercation, did Mr. Farley request that you get back out of his personal space?
Yes.
Did you do so?
Yes, I did.
Immediately?
He hit me first off, yes.
Were you in Mr. Farley's personal space in the outside lobby? Yes or no?
Near him, yes.
Were you in Mr. Farley's personal space when he was attempting to enter from the lobby from the public lobby into the public lobby of the DSH office?
Objection, Your Honor. This calls for speculation on Mr. Farley's subjective intent and feelings regarding.
I didn't ask any questions about intent. I asked if Mr. Rainey was in Mr. Farley's personal space in the entryway of the door. Yes or no?
Okay, I'm going to sustain the objection, and the personal space is a subjective thing from one individual to the next. And you may ask your next question.
Breaking news, the White House National Christmas tree has fallen. A gust of wind knocked it over. Probably a strong gust of wind, about maybe 50% force.
You just viewed the video that the state played?
Yes.
From the video, do you observe yourself being quite close to Mr. Farley during your encounter with him?
Yes, he kept coming toward me too.
Did he keep coming towards you, or were you coming towards him?
He kept coming toward me first off, yes.
Was he trying to come towards you, or was he trying to enter into the lobby?
Objection, Your Honor. Asked and answered.
Okay. And I'm going to sustain the objection on this witness can testify as to another subjective intent.
When you sustained contact from Mr. Farley, Was he requesting that you move back? Yes or no?
Yes.
I don't believe I have any further questions, John. Thank you.
Any
Sorry,
redirect,
is this
Mr.
mic on?
Fortunato?
Your Honor, the city has 2 questions it hopes to ask Mr. Rainey.
2. We're going to hold you to that.
Good afternoon.
You've already introduced yourself.
Did you attempt to take Mr. Farley's phone that afternoon?
No, I didn't.
What were you trying to prevent Mr. Farley from recording that afternoon?
The personnel that were in there, the clientele, a lot of them don't want to be recorded because a lot of times they've just lost their job and or down and they don't want to be recorded while they're in a downside. Would you? I mean, it's what is the reason why. Didn't want to
Objection, Your Honor. I believe that's calling for this witness to speculate on what other persons are thinking. Or
I'll sustain your objection. You can ask your next question. Although you said you had 2, but
That was the
you
only
have
2
more if you
questions.
You can have more if you wish.
Nothing further from the city, Your Honor.
Any recross, Ms. Rowe, in response to those 2 questions?
Basically, you're limited to what were you doing grabbing the phone? That's the only question that was allowed.
Even though you came to the conclusion that persons inside might not want to be recorded, the persons located inside were sitting in a public space, correct?
Your Honor, objection. That's a legal term of art, public space. That's not a question Mr. Rainey can answer.
I'll overrule the objection. He's already answered, and you can ask your next question.
That's the only questions I had, Your Honor.
Anything
Thank you.
further, Mr. Fortunato?
Nothing from the city.
Okay. May this witness be excused?
Yes, he may.
Sit down, sir. Here you go.
Looks like they have one more witness because the co-counsel, who's
Mr.
actually in
Fortunato?
charge.
State have any additional witnesses?
State or city does not have any additional witnesses, Your Honor. The city rests.
Okay. So members of the jury, we're going to take the city is now rested. We're going to take our afternoon recess. I'm hoping
We just
about 10 to
started.
15 minutes, but again, as you've already learned, I'm not a great prognosticator at how long
We've
the
been
break's
here for
going
1
to be.
hour.
But it should be about 10 to 15 minutes, and then we'll come back into session. Take them back.
Okay, let's see if there's any business they have to conduct before they go to the break. Okay, I will say that her final question was good, and they got a good answer. And I'm surprised the judge ruled in favor of her on that one. The coin
You can be
was
seated in the
a
courtroom.
fortunate flip. on
Wait
that
for the
one.
door to close. So Ms. Rowe, your client tends to testify. We're going to proceed to argument. Instructions and argument.
Or would you like to
I
move for a
need to
directed
confer
verdict?
with him for a quick minute.
Would you like to move for a directed verdict at this point? They're not going to get it because there's testimony that there was contact. But you have 2 witnesses. You have 3 witnesses. You have a police officer who did not even go in the building, has no idea what happened in the altercation. You have a witness who describes this guy landing like a 3-punch combo, an assault of this guy. And then you have the security guard who says he was struck once. And the security guard, I'm not trying to fault him, but there are questions as to whether he's a reliable witness due to medical conditions. He's deaf, so we're not sure if he's understanding the questions correctly. So the answer he's given may not be appropriate, and he has some health concerns that might weigh in on his credibility or ability to recall accurately the events. So I think this is a very weak case that the city has presented here. Is he going to testify? If he does, this is going to
Ms.
go
Rowe?
golden.
Your Honor,
Or
if I
step
could,
outside. I can leave the bench for a few minutes.
if you
want to.
wouldn't mind,
Wait,
I just
Let's
need.
limit it to 5 minutes, okay?
That's fine. Yeah,
Okay,
I just
mean,
need to
said
gather my
1:15, It
thoughts.
was 1:45, so let's
Understood.
actually keep to the schedule here.
Understood.
You could borrow my coin if you need help making a decision, says this judge. He should not testify. He won't testify. He's thinking about it, though. Here's the problem. There's a... Why? It looks like the prosecutor is just sort of hovering around to hear what's going. Judge just stepped off the bench, but we're apparently still alive. That rarely happens. Right about now, usually the feed stops. So, who has the hiccups? Did you hear a hiccup? I heard a hiccup. He wants to tell his story. Okay, this is true. This gentleman loves to tell the story. Oh, look, prosecution's doing the celebratory chair spin.
Jury wants trying to watch it.
Quit messing.
Deliberation. It's a laptop. Yeah, that makes sense. Okay.
Yeah, we'll give the laptop. You'll give the jury your laptop, Mr. Lawyer. Yeah, pretty much. Prosecutor thinking he knocked this one out of the park. I'm thinking not so sure. This has to be a unanimous decision, first of all. And this might be a difficult one to reach. So we're watching visually. We cannot hear, but we're watching visually the defendant and the client deciding whether or not he wants to take the stand in his own defense, which he does not have to do. He has the right to not speak in his own defense, and he also has the right to take the stand. He can choose. This is a decision that is entirely his. He should, I would strongly suggest, listen to the voice of his counsel, his lawyer. I'm thinking afterwards this jury is also going to be asked to stick around and answer a quick survey as to who lawyered better. No excuse to punch anyone. I agree. I did not hear anything in the testimony that that would tell me that it would be appropriate response, even in self-defense, for the defendant to strike someone. Unless wait, take that back. The second witness, the one who said there was like a three punch combo that was thrown, that second witness did say the guard put hands on him first. So in that case, there could be some self-defense. I'm not a big fan of, you can only respond with an equal amount of self-defense, the minimum force needed to free yourself from the situation. I don't know if that's the law. I'm not a big fan of those laws at all. I believe that if somebody's putting hands on me, they better be prepared to meet their maker. Okay, because that's how I roll. Right? You don't get that from me very often. Okay, I'm not the one that is advocating violence as a solution. As a matter of fact, I think that in most cases discussion works better than any violence. But if someone does violate that law, that limit, and I am in fear for my life or my safety, or my children's safety or something like that, that's when the daddy bear shows up, and damage may be done. Just saying. Okay, I'm channeling his inner Letitia with a monster can energy. Don't call me Letitia. Anyway, and the threat, not equal force. Seriously, yes, I believe that the response should be consistent until the threat is no longer a threat. That is a great guideline to base it off of. If the person turns and runs away, there should be no force used. You can't throw rocks at somebody as they leave. You can't do that. But if we believe witness number 2, I would say there possibly could be an argument where we say, yes, this altercation, this impact, this blow, the left or the right or whatever it was, could have been in self-defense, which is, interestingly enough, ruled out in motion in limine, that they're not going to argue that it was self-defense. What? When did that happen? And what lawyer would agree to that? I'm a little confused about that whole motion in limine, but instead we've spent the entire trial arguing about the legality of filming in a public building when the charge is assault. Ian Runkle did a great video on analysis of a fight in a convenience store regarding reasonable use of force and what happens when someone disengages from a fight. Ian has some great analysis and takeaways from stuff. Love Runkle of the Bailey. Juror number 1 is biased. Clearly, the fact that he's sitting in the juror number 1 seat, we know that they're biased. And with that, we get to either listen to Darrell Brooks, which we don't want to do. We're going to go back and go back to the waiting game with the courtroom. Refresh. I'm going to get a copyright strike if the kids don't turn down the movie. Hang on one second. One second. All right, I didn't want to leave you completely alone, so I gave you a little bit of music. All right, my luck is that I get picked to sit on a trial like this. You need a little more music. There we go. I was worried. It's a musical they're watching, some Christmas musical. I don't know which one it is, but it had a lot of singing. I thought if I get it picked up, YouTube will strike me, just like happened in the Maya trial. All right. I'm going to go lay down the law in my own home. No, I just informed them they need to turn it down or close the door to that room just so it's a little quieter. Karina, I agree. This was not stellar lawyering. I don't think this was the best that we have observed. USMC retired. The video from the incident, I think the incident itself, I don't think is posted that video yet. We have video from body cams from the police, but that was not his video. I have not seen the actual video of the event from his webpage. Are you seeing it out there? Maybe I just was looking at the wrong thumbnails. I think this was a high school mock trial. So Tom, this there are two schools of thought, right? That we've seen, and they're represented both strongly here. And I'm not trying to call out one or the other, but there are two schools of thought when it comes to this. The first one is, why in the world would you be filming there, right? Why would you go into a place where people who've just lost their jobs, who have had family tragedies and are having to appeal for government assistance to get by? They're clearly at a low point in their life, right? Things are not going well. Why would you go in there and film? Okay, just common sense. Think that through. Why would you put somebody who's having to crawl to the government and beg to survive on a video and be like, hey guys, look what's happening in here? That is heartless. Okay, that is it's just not right. So there's that school of thought, and there's also the other school of thought that public place, according to the Supreme Court rules, there is no expectation of privacy. And basically, if you are allowed to be there in a public place, you're pretty much allowed to film there. And you can, anything you observe from a place you're allowed to be, you can film. That's basically how the law goes. Don't quote me on this. I'm not a lawyer. I would not take my advice as, a plan for your next family vacation and what you plan to do in any situation. But you've got these two competing, RA court. Hang on. Let's see. He's back. Okay. Here we go. We're going to back up. I'm like 2 minutes back. We're going to back up and we're going to listen to it a little bit live. Here we go. Cut here. Okay. Sorry. I was on a spiel. I was doing my spiel. Playback 1.25 because that's how we roll. He is going to testify.
Your Honor, after speaking with my client, I believe that he is going to take the stand.
Okay, we'll bring the jury back in.
So we're like 2 minutes behind. We're going to catch up, and then once we're caught up, it's going to slow down automatically.
So we'll remove the instruction.
We're going to remove there's jury instruction talking about if he chose not to testify, you shouldn't hold that against him. Good thing we love you, says Bug Dugger. Thank you. Appreciate your patience. Yeah, buckle up. This is going to get really fun.
Instruction that says he's not required to testify. We're just going to remove that.
Thank you.
Thank you. You're welcome.
Jamie, I'm not sure which one it's going to be, but I think you're right. I don't think this will be down the middle. I was in the middle of my monologue. It was almost a soliloquy. How's that for an English word? The prosecutor just got the goosebumps. Here we go. Where is this? This is in Thurston County.
Jury, recall the state rested. Ms. Rowe.
Thank you.
You make all your proof witness.
Thank you. And I would call Mr. Jeremiah Farley.
Mr. Farley, step right up. You're the next contestant on what court is this anyway?
You raise your right hand, please. You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth. You may be seated.
Just get right comfy there.
Ms. Rowe, you may inquire.
Thank you. Mr. Farley, could you identify yourself for the record?
My name is Jeremiah Farley.
Can you point to yourself and identify some item of clothing you're wearing? Oh, never mind. We don't need that.
Mr. Farley. Do you remember the incident that is at issue at trial today?
Yes.
And were you present at the DSHS office on the date of this incident?
Yes, ma'am.
Did you have business there?
Yes, ma'am.
Did you come into contact with Mr. Randy Rainey, the security officer?
Yes.
Did your contact with Mr. Rainey begin in the main hallway?
Yes, ma'am.
Did Mr. Rainey try to prevent you from entering into the DSHS office?
Objection, Your Honor. Speculation.
Okay. Overruled.
Yes, ma'am.
Did the contact that occurred happen in the threshold or doorway of the DSHS office?
Yes, ma'am.
Who made contact with who first?
Mr. Randy made contact with me.
Was that contact warranted? Yes or no?
Objection, Your Honor.
Sustained.
Thank you.
Was that contact
Consensual.
offensive?
Yes.
Was it
Did you notify security guard Rainey that his contact was offensive?
Yes, ma'am.
Objection, Your Honor.
Okay, I'm going to overrule that objection.
Thank you.
Thank you for overruling.
Did security guard Rainey touch you more than once?
Yes, ma'am.
Was security guard Rainey very close to your physical person?
Yes, ma'am.
Did you ask him to get out of your personal space?
Objection, Your Honor. Leading.
Sustained.
What did you do when security guard Rainey was in your personal space?
Objection, Your Honor. Leading again.
Yeah, that'll overrule that objection. Can you repeat it, please?
What did you do when security guard Rainey came into your personal space?
I tried to move him out of my personal space.
Did you tell him to back up?
Objection, Your Honor. Leading.
Sustained. But
how many times did security guard Rainey come very close to you?
Multiple times.
At any time, did you ball up a fist and punch the security guard?
No, ma'am.
Please describe the contact that you had with security guard Rainey.
He had me in a corner. I felt threatened. I didn't know why he was coming at me. So I pushed him away from me multiple times.
Did he sustain any injuries from those pushes?
Objection, Your Honor. Calls for
I'll
speculation.
sustain that objection.
Were there any visible injuries as a result of this contact?
Objection, Your Honor.
Sustained.
Did you speak to a supervisor at the DSHS office?
Yes, ma'am.
Did you ask the supervisor whether the inside lobby was a public space?
Objection, Your Honor. Leading.
Sustained.
Did the supervisor
They're all leading questions.
call law enforcement?
Objection, speculation, and hearsay, Your Honor.
Sustained.
Speculation.
You did have communication with the supervisor?
Yes, ma'am.
I know it's a tough thing for a defense attorney to do with your client on the stand, but you have to let him talk. You have to ask questions in such a way that he can tell the story. You can't lead him through this.
Did you converse with responding officer Navarro?
Yes, ma'am.
And did you relay to him your version of what happened that day?
Yes, ma'am.
What is your version of what happened that day?
Thank you, Your Honor.
That's all?
Just hoping to be very brief.
Now they get a free shot at him, and he did nothing.
Good afternoon, Mr. Farley. The video we watched, that's your recording of the events of the day. Is that correct? What was your business at the DSHS office in Tumwater that day?
My own business.
Your own business?
That's what I said.
Careful, that's not going to work very well in court.
1 moment. You said your own business.
What was that business?
Would you elaborate a little further for us?
I was there to gather a FOIA request or a records request, I guess is what most people would call it. I videotaped the entry lobby to look at the community boards, different activities, different social groups, anything that there might be going on in the community. And then I attempted to go get my records request.
You pushed the security guard to get away from you? Is that true?
Yes, sir.
You physically touched Mr. Rainey, is that correct?
Yes, sir.
You did not let any of the patrons there that day know in advance that you were going to be recording them, is that correct?
Objection, Your Honor. Leading and outside of the scope of
It's on
direct.
cross.
Leading questions are allowed on cross-examination. And you allow an answer to this question, then you need to move on after that.
Okay.
Can you repeat it again, please?
You did not let any of the patrons that were present that day know in advance that you were going to be recording them. Is that correct?
That's correct, sir.
No further questions, Your Honor.
Ms. Rowe, anything further?
Yes, one last question.
Slams his papers down.
Were you recording individuals in the lobby?
No, no, ma'am.
Was that your last question?
No further questions.
All right.
You can go ahead and take your seat, sir.
Thank you.
Assuming, was there any redirect?
Oh, no redirect or recross, rather.
Ms. Rowe, do you have any additional witnesses?
I do not, Your Honor.
Again, we're going to that was a quick session, but we're going to take a quick break. And this one, I'm pretty confident that this will not be very long. And then you'll come back in, you'll get instructions on the law, and you'll hear argument from counsel. So go ahead and take a minute back. And again, I should have said at the last break, but all the instructions I've given remain in place. Don't begin deliberating. Don't discuss anything that you've heard thus far. You should be back in session in a few minutes.
They put him up on the stand making him open to answering questions from.
So you can be seated.
From the prosecution.
With regard to jury
and
instructions.
Didn't have him tell the story.
I've looked over the break, looked at the statute, the instruction offered by the state about the unlawful for any individual, partnership, corporation, association, and so forth, whether or not to give that or not. I'm declining to give that instruction, primarily because it talks about a private conversation on a device. Looking at that statute, it's geared more towards eavesdropping or wiretapping or things of that sort, and I don't think it's appropriate in this particular case. Ms. Rowe indicated that she wished to explore the concept of defense of property.
So they slow down.
I'm not going to give that instruction either. The instruction, I've got that up in front of me here. It says the use of force upon another person in preventing or attempting to prevent a malicious trespass or other malicious interference with real or personal property lawfully in that person's possession when the force is not more than necessary. In this case, there was no malicious attempt at malicious interference with real property. Property was lawfully in Mr. Farley's possession, but as far as I can tell, the evidence supports Mr. Rainey just wanted to stop him from recording in a place he wasn't supposed to record. That's not a malicious interference. And when the force is not more than necessary. I saw the video. I heard the testimony from both parties. Any force was more than necessary. Mr. Farley could have prevented this whole thing simply by stopping his phone, putting it in his pocket, and that would have been the end of it. And so also, person offering to use the force, and in this case, Mr. Farley is apparently indicating that he used the force that a reasonably prudent person would use under the same or similar conditions, or they appear to the person taking into consideration all of the facts and circumstances known to the person at the time of and or prior to the incident. Again, getting back to the property, this is, I think, appropriate when someone's trying to steal some property from somebody and they can use force to prevent that. Mr. Rainey, I don't think the evidence supports that he was trying to steal Mr. Farley's phone. He was just trying to, again, prevent Mr. Farley from recording in a place he wasn't supposed to be. So I don't think a defense of property's instructions appropriate here either. So I'm not going to give that. And then that's where we're at.
Thank you.
And so I have the instructions here. I've removed that. You can take, I have one both for you and your attorney, Mr. Farley. I have
luckily the jury's not in the room for this.
At the state's table.
Is diatribe? Is that?
I'm sorry, Your Honor. I didn't hear that last part.
I said I have copies for Mr. Farley and Ms. Rowe, and I have copies for both attorneys at state's table.
City.
I
appreciate that.
Okay.
Thank you, Your Honor.
You're welcome.
I wish we got to see the judge's face if the jury returns a not guilty verdict.
What we usually get when recordings have been sent back to the jury, because they're not going to have a means to play it. They'll probably want to, at some point, they may ask to review that recording again by practice there. Just going to bring them in there. And we have them into the court, have them play it without comment, and then send them back.
Okay, we do have the laptop here.
Right.
If the court was, the state's request is that they just view it in the jury room, but the laptop is scrubbed.
Okay.
It's not connected to the networks or anything like that, or any information like that. But it is here. Logins also on the screen.
Well, let's wait and see if they request it. Now we can deal with it at that time.
Okay. The only other request, Your Honor, is I might as well just do it now, is after the jury returns a verdict,
Yes, we want to pull them.
we would ask that the court relay to them that this is Mr. Fortunato's first trial, and that we would seek feedback if they're willing to stick around and give some.
Okay.
Please stay afterwards to complete a survey, as if your jury pay was the pittance you received was not insult enough. We'd like you to stay afterwards and tell us how good a job we
did. You need
did.
a minute, or we could bring the jury back in and proceed.
City is
instructed. You can argue.
City's ready to proceed, Your Honor.
Ms. Rowe?
I am, will the court be going over the jury instructions before we do closing?
Yes.
Okay.
I instruct and then argue.
Right.
And Your Honor, the state does have a standing objection at this point to any argument regarding self-defense, defense of property that might be made during closing arguments.
Do you understand that, Ms. Rowe?
I do.
Okay.
I cannot
We can bring them
believe,
back in.
First of all, that argument is there. You literally have an assault charge. Self-defense is a valid defense. And she, as a lawyer, said that's fine. We're not going to go the self-defense route. We're not going to bring up self-defense. We're admitting to punching the guy in the face. We're admitting to making contact with this guy, which meets the definition of assault, but we're not going to say it was self-defense. So we're fine with that instruction. What can the jury do other than find him guilty at this point? I don't know if they have an option other than find him guilty. The poll was, will the jury find the defendant guilty? We're about 2/3 yes, 1/3 no is where we're at right now with 154.
You can be
votes.
seated in the courtroom.
We're going to end the poll really quickly. 155.
Members of the jury, when you came back in on your seat, there was a packet of jury instructions. I'm going to read those to you in advance of as the attorney's arguments. I've observed over the years people have different learning or listening styles. Most people follow along as I read them. Not everyone does. However you decide to listen to these instructions is fine with me. It's all up to you. But the law that will apply in this case is as follows. Instruction number 1. It is your duty to decide the facts in this case based on the evidence presented to you during this trial. It is also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proved, and in this way, decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during your deliberation consists of the testimony that you have heard from witnesses, stipulations, and the exhibits that I have admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the court clerk and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings on the evidence. If I have ruled that any evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all of the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things that he or she testifies about, the ability of the witness to observe accurately, the quality of the witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all of the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It is important for you to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits, and the law is contained in my instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. You may have heard objections made by lawyers during trial. Each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on a lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express by words or conduct my personal opinion about the value of testimony or other evidence. And I have not intentionally done this. If it appeared to you that I have indicated my personal opinion in any way, either during trial or in giving these instructions, you must disregard this entirely.
We saw it.
You have nothing whatever to do with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions, and during your deliberations, you must consider the instructions as a whole. As jurors, you are officers of this court. You must not let your emotions overcome your rational thought process, and you must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. And to ensure that all parties receive a fair trial, you must act impartially and with an earnest desire to reach a proper verdict. Instruction number 2. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors, nor should you change your mind just for the purpose of reaching a verdict. Instruction number 3. The defendant has entered a plea of not guilty. That plea puts in issue every element of the crime charged, and the state is the plaintiff and has the burden of proving each element of the crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists as to these elements. The defendant is presumed innocent. This presumption continues throughout the entire trial unless, during your deliberations, you find it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If, from such consideration, you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. Instruction number 4. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case, and one is not necessarily more or less valuable than the other. There is no instruction number 5. Instruction number 6. A person commits the crime of assault in the 4th degree when he or she commits an assault. Instruction number 7. To convict the defendant of the gross misdemeanor of the crime of assault in the 4th degree, each of the following elements of the crime must be proved beyond a reasonable doubt. 1, that on or about July 20, 2023, the defendant assaulted Randy Ramey. And 2, that this act occurred in the city of Tumwater, Washington. If you find from the evidence that each of these elements have been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if, after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, 1 or 2, then it will be your duty to return a verdict of not guilty. Instruction number 8. An assault is an intentional touching or striking of another person that is harmful or offensive, regardless of whether any physical injury is done to the person. A touching or striking is offensive if the touching or striking would offend an ordinary person who is not unduly sensitive. An assault is also an act done with intent to inflict bodily injury upon another, tending but failing to accomplish it, and accompanied with the apparent present ability to inflict the bodily injury if not prevented. It is not necessary that bodily injury may be inflicted. An assault is also an act done with the intent to create in another apprehension and fear of bodily injury, and which in fact creates in another a reasonable apprehension and imminent fear of bodily injury, even though the actor did not actually intend to inflict bodily injury. Instruction number 9. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Instruction number 10. When you begin deliberating, you can first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has the chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 6 jurors are present. You are all officers of this court and must evaluate the evidence with an open mind, free of bias or prejudice. If during your deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During your deliberations, you may discuss any notes that you have taken during trial if you wish. You have been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case, and testimony will rarely, if ever, be repeated for you during your deliberations. If, after carefully reviewing the evidence and instructions, you feel the need to ask the court a legal or procedural question that you have been unable to answer, write the question out simply and clearly. For this purpose, use the form presided in the jury room. In your question, do not state how the jury has voted, and the presiding juror should sign and date the question, give it to, says bailiff, but in our case, clerk, and I will confer with the lawyer to determine what response, if any, can be given. You will be given the exhibits admitted in evidence, these instructions and verdict forms for recording your verdict. Some exhibits and visual aids may have been used in the court, but will not go with you to the jury room. And the exhibits that have been admitted into evidence will be available to you in the jury room. You must fill in the blank provided in each verdict form, the words not guilty or the word guilty, according to the decision you reach. Because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict form to express your decision. The presiding juror must sign the verdict form, notify the clerk, and the clerk will bring you into court to declare your verdict. Those members of the jury are my instructions that will apply in this case. Would you now please give your attention to Mr. Fortunato for his closing argument on behalf of the city of Tumwater. Mr. Fortunato.
Last chance to make a good impression right here.
Good afternoon,
on your
everyone.
first trial,
I appreciate your attention throughout this trial. You've heard a lot of information today, but I want to remind you that you're here to determine if Mr. Farley is guilty of assault in the 4th degree. The city has met its burden of proving that Mr. Jeremiah Farley assaulted Mr. Randy Rainey on July 20th, 2023 in the city of Tumwater, Washington. All the legal information I share with you will be in your jury instructions, and be sure to refer to these instructions for guidance for any questions on the law. If at any point the city or defense misstates the law, follow as written in the instructions. Do not apply laws that are not in the instructions. With that, please keep in mind that to be found guilty of assault in the 4th degree, the prosecution must prove 2 things: that the defendant assaulted someone and that it occurred in the jurisdiction. If you could turn to jury instruction number 8, you could follow along with me. An assault is an intentional touching or striking of another person that is harmful or offensive, regardless of whether any physical injury is done to the person. A touching or striking is offensive if the touching or striking would offend an ordinary person who is not unduly sensitive. Based on this, the city has met its burden of proving Mr. Farley's guilt beyond a reasonable doubt. Through testimony of Officer Peter Navarro, Mr. Sam Kirkley, and Mr. Randy Rainey, as well as the video that was recorded by Mr. Farley, the city has proven the following. Mr. Farley entered the Department of Social and Health Services office in Tumwater, Washington, and began recording on his devices. He was advised that he was not allowed to record people in the waiting area. Mr. Farley disregarded requests to stop recording and continued into the waiting area of the office, all the while continuing to record. Mr. Rainey motioned toward Mr. Farley's recording device, in an attempt to prevent him from continuing to record the DSHS patrons. In jury selection, you all uniformly agreed that confidentiality and security were two of the main valid reasons for forbidding recording in government administrative offices. Here, DSHS patrons certainly share sensitive and personal information. Mr. Rainey intervened in this situation to ensure that these patrons' confidentiality and privacy, as well as their safety, were protected. Mr. Farley twice struck Mr. Rainey and aggressively shoved him in an attempt to continue his recording. This recording issue provides context, but again, I want to remind you that you are here to determine if Mr. Farley is guilty of assault in the 4th degree. This requires two elements: that Mr. Farley assaulted someone and that it occurred in the city of Tumwater. Mr. Farley does not contest that the acts occurred in the city of Tumwater, the county of Thurston, and the state of Washington. The city has proven beyond a reasonable doubt that Mr. Farley intentionally struck or touched Mr. Rainey in a manner that is offensive. Mr. Farley twice hit Mr. Rainey in the face and also shoved him aggressively. Undeniably, this touching and striking would offend an ordinary person. Mr. Farley assaulted Mr. Rainey. Once again, I urge you, consider the testimony that's been presented to you here today throughout this entire trial. Consult the published exhibits that will be available to you in the deliberation room. And most importantly, refer to and follow the jury instructions strictly when it comes to the law. Because the city has met its burden in establishing that Mr. Farley assaulted Mr. Rainey in Tumwater, Washington, Mr. Farley is guilty of assault in the 4th degree. The city requests that you return a guilty verdict. Thank you.
Short and sweet.
Members of the jury, would you please give your attention to Ms. Rowe for her argument on behalf of Mr. Farley?
Thank you, Your Honor.
It's Kelvin. It's Kelvin. Adam.
We are here to decide if Mr. Farley assaulted Security Officer Rainey. My closing is going to walk through the evidence that was presented today. The state's first witness was Officer Peter Navarro. Officer Navarro indicated that he has been a law enforcement officer since 2018, that he received extensive training to become a police officer, and this included assault training, and he indicated that he has executed at least hundreds of investigations. What I do find interesting is that when asked, Officer Navarro indicated that he had never arrested individuals for videotaping, video recording at all. We are not disputing that the incident occurred on July 20th. We are not disputing that the incident occurred at the DSHS office. But Mr. Farley's version of the event are much different than the state's. It was very important for the state to ask each of its three witnesses to describe the layout of the DSHS office. That's very important because where Mr. Farley entered into the building is very important. Mr. Farley didn't enter the building on the entrance that's closest to the parking lot. Mr. Farley did not enter the building by the interest that's closest to the security guard corner. Mr. Farley did not enter the building in the interest where a notice was posted regarding the use of video recording. Mr. Farley attempted to enter into the DSHS office on the far entrance. That's very important to take note of. Going back to Officer Navarro's testimony, he indicated that the east entrance where Mr. Farley entered consists of a long public hallway where there are bulletin boards placed throughout the hallway. That at the end of this long hallway, there are double doors on the left side of the hallway that are the entrance from the hallway into the DSHS office. We also know from everyone's testimony that Officer Navarro was not present and did not witness the incident himself. In fact, Officer Navarro and other officers responded to a dispatched call. Officer Navarro indicates that he wasn't even the officer who took witness statements, the witness statements from the witnesses inside the DSHS office, but that he, and his role that day, was to take Mr. Farley's version of the story. When asked, Officer Navarro indicated that Mr. Farley's demeanor was polite, was respectful, was conversational, and that he was straightforward in his answers. He did note, however, when asked about his facial expressions, that Mr. Farley appeared to be concerned. Then we heard Officer Navarro testify that when he contacted Mr. Farley also recorded their communication. When asked whether he had any concerns over being recorded himself, he indicated he had no concerns. Officer Navarro asked Mr. Farley what was his purpose of being there, and Mr. Farley gave him a straightforward answer, told him that he was there to record the normal business practices and the daily activities. He indicated, and I believe Detective Officer Navarro indicated, that Mr. Farley said he was a freelancer reporter of public buildings. When asked whether or not that concerned Officer Navarro, he said he had no concerns over that at all. When asked, Officer Navarro indicated that the hallway, or Officer Navarro testified that the hallway leading to the DSHS office, DSHS, that's a little bit of a tongue twister, that Mr. Farley was in public space. When asked, Officer Navarro also testified that the lobby portion of the DSHS office is also public space. Officer Navarro indicated that Mr. Farley relayed to him that his belief that he had the right to record in public spaces. He told Officer Navarro that security guard Rainey got into his personal space, that he backed up in an effort to de-escalate the situation, that there was discussion had that led into the touching altercation.
It was a touching altercation.
Officer Navarro indicated his understanding that the DSHS supervisor was called, and he indicated that what Mr. Farley represented to him appeared to be quite a bit of chest bumping and shoving back and forth, but that all of that contact occurred basically in the east entrance doorway before Mr. Farley had even gotten into the lobby. When asked, Officer Navarro indicated that Mr. Farley did not resist, and Officer Navarro taking his devices as they could be used for evidence. Never at any time did Officer Navarro indicate that there was a need to subdue or restrain Mr. Farley. He wasn't attempting to get away. He wasn't attempting to leave. In fact, by his testimony, it appeared that Mr. Farley went out once he saw law enforcement had arrived. It was Officer Navarro's duty under his job as a law enforcement officer to record Mr. Farley's version of events that day. When asked whether or not Mr. Farley denied touching Security Officer Rainey at all, the response Officer Navarro said was that Mr. Farley told him he did what he needed to do to protect himself. Officer Navarro also indicated that outside of his taking Mr. Farley's statement, he did not interview any of the other witnesses. I want to go back to Officer Navarro's explanation of the layout of the land, so to speak. Officer Navarro indicates that to his knowledge, there are signs posted inside the lobby, in the security area, and on the middle retaining wall regarding the use of video recording. When I showed the pictures of the layout of the land, so to speak, officer identified 2 areas where this notice was located, where these notices were located. These notices were located on the middle retaining wall, far away from the entrance that Mr. Farley entered in. He indicated that actually the communication started in the hallway. The altercation took place just inside of the door, and that the notices regarding recording were in the middle of the room in the lobby. When asked, Officer Navarro assumed that or believed that DSHS does have its own recording cameras. He also indicated he did not personally view any camera footage from DSHS regarding the incident. I find that very important to stress because there may have been other video evidence out there that could have shown a clearer picture of the incident.
Your Honor,
But we are left
I have
with
to
this
object.
recording.
That includes facts,
Just
not
hang on a
evidence.
second. I'm going to remind the jury that the lawyer's remark statements are not evidence. The evidence is contained in testimony. The law is my instructions. With that, Ms. Rowe, you may continue.
Officer Navarro indicated that Officer Security Guard Rainey asked Mr. Farley to stop recording in the hallway. That was not restrictable behavior. We also noted, and Officer Navarro testified, that Mr. Farley was not cited nor arrested for recording. In fact, that's when he indicated that he has never arrested anyone for recording in a public space. He also indicated that no patrons from inside the DSHS office came out and relayed any privacy concerns that they may have had. He made a point to testify that it did not appear Mr. Farley was attempting to invade investigation. And lastly,
we're almost done.
According to Officer Navarro, Mr. Farley had no prior knowledge of any rule of DSHS. I next want to bring your attention.
You said lastly already.
To the testimony of Mr. Kirkley, who was a witness.
Oh, this was the good
Mr.
one.
Kirkley testified what business he had at the DSHS office that day. And he also testified that he personally did not see any signs inside the DSHS office regarding recording. He again described the layout of the DSH office, and when shown the pictures of the layout of the land, he confirmed that that's what the inside of the law office looks like. He also testified that this incident and basically the hullabaloo that began started in the public corridor. They weren't even in the office yet. He indicated that he personally did not see them come in, but heard a scuffle, and he knew the topic that was being discussed was recording.
Her opening statement was very small. It wasn't long.
When asked if any employee of DSHS came out to advise Mr. Farley of any recording rule, he did not recollect any employee of DSHS notifying Mr. Farley of this.
She really wants to defend him on this video camera charge, which doesn't exist right now.
He indicated that he saw security guard Rainey basically lunge for Mr. Farley's recording device not once, not twice, but 3 times. He heard Officer Rainey referencing not recording these people without asking their permission. When Officer Rainey lunged for Mr. Farley's recording device, he heard Mr. Farley tell him, "Don't touch me. Get off me. Don't touch my phone." He indicates that Mr. Farley was holding his cell phone in his hand. And he indicated that when security guard Rainey was attempting to go towards his recording about device, that Mr. Farley did everything he could to keep his recording device out of the reach of Mr. Rainey. When asked, he indicated that it did appear that security guard Rainey was invading his personal bubble, his personal space. He may have testified that he believed there was good reason for that, but that's what he testified to. I find it also very interesting that his testimony was that Officer Rainey was calm, was not yelling, wasn't threatening. I believe that the video that was shown depicts otherwise. There was a lot of loud noises, scuffling that we heard on that video. But again, Mr. Kirkley indicated that the communication between Mr. Farley and the security guard was extremely close in proximity. He indicated that Mr. Farley responded in a defiant and agitated manner, stating what he believed to be his rights. Mr. Kirkley then went on to describe what he perceived was Mr. Farley balling up his fist and actually punching security guard Rainey. But I would argue that the video recording shows otherwise. Had Mr. Farley had the chance to step away, ball a fist, Mr. Farley, and punch him, that did not happen. He didn't have that chance. Security guard Rainey was all in his face, all up in his personal bubble.
He was all up in that bubble.
And what he did was to push him back multiple times. We heard from Mr. Kirkley that this officer went for the phone 3 times. But when asked how hard his perception of the hand strike was, it was about 50% power.
Loaded my bicep with 50% power.
He believed the security officer never broke training protocol, but that was just his personal belief. He indicated that he heard Mr. Farley yell, "Don't touch me, don't take my stuff." He assumed that Mr. Farley had no other business there than to cause problems. But we know what assuming can do for an individual.
No, tell us. I remember it makes a donkey out of
He
you and me.
indicated that throughout this process, Mr. Farley was continuing to record this incident. He noted the tenure of the patrons in the lobby. He noted that everybody was upset and there was a big hullabaloo, which is understandable when an incident such as this happens. He indicated that during this incident, or shortly thereafter, that administrative personnel of DSHS came into the
I'm sorry, did she just
lobby
yawn during her
and
presentation? Excuse me, did anyone catch that?
worked to de-escalate the situation. He also supported Officer Navarro's testimony that there were patrons who went to law enforcement to give statements. Unfortunately for us, we only heard from one of those witnesses today, even though there were multiple witness statements given. We don't know if there were witness statements that corroborated
Subpoena
or refuted Officer Rainey's version of the story. We do know that the witness that the state chose to bring forward supported their position. I also want to point you to not the one time and not to two times, but to the three times that this witness testified that he didn't think the security guard should have tried to take Mr. Farley's phone. If I could, Your Honor, please. I need to take a sip of water.
This is the longest lastly I've ever
He
heard.
reiterated that 3 times. He indicated that this whole thing didn't have to happen. I would argue that he is absolutely right. This whole incident didn't have to happen. Unfortunately for Mr. Farley, it did. And that's why we're here. He indicated on cross-examination that the security officer appeared to be trying to stop Mr. Farley from entering into the office at all. Those were not part of his job duties. He was not assigned the duty of accepting or refuting persons who want to come to the office because they have business to attend to. Additionally, Mr. Farley does not have to tell other persons what business he was there for. He is a grown individual who did not have to answer that question. So even though he testified that he didn't have any knowledge of Mr. Farley's business, it does not mean that Mr. Farley did not have business there. I then want to bring your attention to the testimony of security guard Rainey himself.
We're only on the third witness here. We haven't
He
even got to the
indicates that
fourth
he's been a
witness,
security
which was
guard for
the defendant.
12 years and that he has worked at DSHS for 3 years. He also confirmed the layout of the land that the two prior witnesses had described. And he indicates in his own testimony that the lobby is a public space. And when asked, his specific words were, "You can record in the lobby." He was asked this again, in fact, by the state. And once again, he reiterated, recording is allowed in the lobby. It's not allowed behind that half wall barrier, but it is allowed in the lobby. On the video, you will see Officer Rainey lying to Mr. Farley. Mr. Farley asked him, "Is this a public space?" And he said, "No, this is not a public space." Now, he corrected that lie on the stand today, but you will see.
Your Honor. I'm gonna sustain the objection. And yeah, I'll sustain the objection.
The video will show that Security Officer Rainey informed Mr. Farley that that was not a public space. Today, he testified that it was. Then we started talking about where the notices were located in the office itself.
We're reliving this trial in
Security
real time.
Officer Rainey again pointed to the signs that were located in the middle of the lobby, on the wall and the pillar, and on the far side in the security guard corner, which was not the side that Mr. Farley entered the building on. That's very important. When asked, once again, Officer Rainey indicates that Mr. Farley was not made aware of the rule at first. He testified the incident occurred in the lobby and at the threshold. He indicated that he ordered Mr. Farley to leave the building. Once again, that was outside of his job duties. He did not have the duty to order a private citizen to leave a public building where that private citizen came to conduct.
Sustained. You need to move on then as well.
Okay.
Don't say move on, say wrap
He
up.
simply ordered him to leave the building. And this was before he had even crossed the threshold. He indicates that he was struck on the left cheek. However, we have seen no pictures of any injuries that were sustained by Security Officer Rainey. He indicates that he believed he was talking to Mr. Farley in a quiet manner. I would argue otherwise. He indicated that he stepped back when asked by Mr. Farley, but the video will show otherwise.
Here for the Truth says, let's play How Many Ways Can You Say the Same Thing? Sorry, it doesn't show up very well on this.
When asked, Security Officer Rainey indicated that it is not part of his job description to attempt to exert any control over another person's personal property. In fact, when asked what was the procedure that he should have been followed, he indicates that he would call his supervisor or call law enforcement. Those are where his duties stopped and where the duties of law enforcement kick in. Mr. Farley was there to conduct business in a public space at a public agency, and he wasn't even given the opportunity to record in a public space.
Okay, she's been speaking for over half an hour here. I think she needs to
When
sort of wrap
asked
it up.
why he didn't inform Mr. Farley what sections of the office, the inside office, Mr. Farley was able to record and which sections were the actual restricted areas, he said on 2 or 3 occasions, it didn't come up. Well, it should have come up. That was his job description.
Dinner is
His
lasagna.
job was to inform the public where they could and could not record video. He did not do his job. He jumped to conclusion. He jumped to act before he had the authority to. When we asked him whether he saw Mr. Farley recording specific individuals, he indicated no. He didn't see what Mr. Farley was recording. Instead, he jumped to attention. When asked specifically whether his job description includes touching another individual, his response was, he is not allowed to touch someone unless he's being attacked. He touched Mr. Farley first. And at that time, he was not being attacked. In fact, we would argue that security guard Rainey was never attacked. He was pushed out of Mr. Farley's personal space.
Sorry, I'm getting bored and
I
moving
want
things around.
to also reference the questions that were discussed in jury selection.
Found the right
When
button.
asked-
There you go. Okay, now we're back.
Whether or not how many persons would stop recording just upon demand, several of the jury pool
Just going back to
indicated
jury voir dire.
that would not be enough to make them stop, that they'd need more. In fact, I believe it was represented that
Why is she going
security
back to voir
guards
dire?
don't always get it right. They are not versed in the law
Please object.
and may not be accurate in the law. I lastly want to bring your attention to the jury instruction that focuses on what an assault is. Jury instruction number 8 begins by saying, an assault is an intentional touching. That was done by Security Officer Rainey. An assault is the intentional touching that is harmful or offensive. We heard testimony from Mr. Farley that the initial touching and the continued aggression.
Your Honor, may we have a sidebar?
I'm going to sustain the objection. You could move on, and then we'll go from there.
This judge's soul left the body.
We'll just allow you to continue, Ms. Rowe.
Thank you. Security Officer Rainey intentionally touched Mr. Farley.
Objection, Your Honor. Again, same purpose here.
Okay, members of the jury, we're going to have you go back into the jury room.
Record scratch.
This should be pretty short.
It should be really short. It should have been much shorter than it is. Oh my goodness. Okay. Look, I am all for Mr. Farley getting his day in court. I'm not a big fan of this attorney's plan to rehash everything, including every question asked of every witness, and even going back to jury selection.
Your Honor, this is precisely what was mentioned immediately prior to closing arguments. This is going down the line of speaking into, or what our speaking objection was, that this is the defense of self-defense. This is exactly what Ms. Rowe is attempting to do here. She's attempting to backdoor this self-defense argument. She is attempting to say that Mr. Rainey was instead the person who assaulted Mr. Farley, and that is going down the line, of course, into justifying his pushing of Mr. Farley, or of Mr. Rainey, rather.
Ms. Rowe?
Your Honor, I disagree with that analysis. I am simply reading the jury instruction.
Okay.
And
no, you're not. You're saying that, I thought I heard you say Mr. Rainey is assaulting Mr. Farley. Intentionally touching.
I said he intentionally touched Mr. Farley.
Yes, that's what you said. That's not reading the jury instruction. Okay, the jury instruction is the definition of an assault. You're kind of citing what would be a to convict instruction if Mr. Rainey were accused of assault and on trial here, which he is not.
Okay.
And so the issue here is whether or not, in this trial, is whether Mr. Farley assaulted Mr. Rainey. That's it. And so I would confine your arguments to that issue. So as we discussed, the defense of others, it's not before the jury, can't argue that. And so let's assume for the moment that even if Mr. Rainey did assault, that doesn't have anything to do whether or not Mr. Farley assaulted Mr. Rainey. So avoid that argument. We're going to bring the jury back in. Mr. Rainey's not on trial here. And so it's not even an issue as to whether or not he assaulted Mr. Farley. And frankly, the evidence doesn't support that based on, if you look at the video combined with the other testimony.
Judge.
And again, that's not even an issue for this trial. The issue is whether or not Mr. Farley assaulted Mr. Rainey. That's it. And so we can, do you understand that?
I understand, Your Honor.
Great. You can bring the jury back in and you can continue.
I'm not sure where she's going to continue to. There's nothing else to cover, unless she starts talking about what she had on lunch break and, you know, attorney-client privilege conversation. She's talked about everything that's happened in court to this moment. Okay, Mrs. Homeschool Ground Zero, Mrs. R.A. Let me just say, I have no idea why they agreed to rule out self-defense as something that the defendant can bring up, because literally self-defense is a defense to assault.
In conclusion,
yay!
The state has to prove the elements of the crime. And it is your duty to find that the state has met its burden beyond a reasonable doubt. In this case, we would conclude that there is reason to doubt in this case. And if you conclude so, you will find Mr. Farley not guilty. Thank you.
Thank you, Ms. Rowe. Members of the jury, the state carries the burden of proof in these cases, and as such, they're entitled to a rebuttal argument. So for one last time, would you give your attention to Mr. Fortunato for his rebuttal on behalf of, when I said state, I meant city, on behalf of the city.
Thank you, Your Honor. And I promise I will keep this very brief. I have three things to tell you. One, what myself, on behalf of the city of Tumwater, and Ms. Rowe say are not evidence. What we characterize things as is not evidence. Evidence is evidence, and you will be provided with exhibits when you deliberate. Number two, you are here to decide whether or not Mr. Farley assaulted Mr. Rainey. Not where Mr. Farley was in a hallway. Not whether Mr. Rainey was in Mr. Farley's personal space. And not whether Mr. Farley had sufficient notice of the DSHS's office policy regarding recording devices. And number three, follow your jury instructions. Thank you.
And please stick around after for a brief survey.
With the exception of you, sir, in the maroon chair, I think that is. You're the alternate, and so what's going to happen is that jurors number 1 through 6 are going to go back to the jury room to begin their deliberations. Juror number 7, you're still the alternate. You're still on call, so to speak. I have had the experience where juries have begun to deliberate, and then something happens, some emergency arises, someone has to leave. We have to call in the alternate, and then you have to start all over. So even though you're going to get to leave in a minute, your job isn't over yet. I do want you to give your contact information to the clerk, and when a verdict is reached, one way or the other, we'll contact you, let you know, and then all the instructions will be lifted at that time. But until then, until you hear from us, all the instructions will remain in place. So jurors number 1 through 6, you can go back to the jury room. Yes, sir? Will the video be available to us in the deliberation? Well,
they want to watch the video. They're already saying we want to watch the video.
If you wish, I'm going to have you go back there and begin your deliberations. If you wish to view it again, you can let the clerk know, and then we can, and then talk amongst yourselves. If you wish to view it again, you can be brought back in to view it again. Okay?
They want to watch it in slow motion. Okay, we are going to start the jury selection clock, which is on my watch right here. Sorry, I wish I could bring it up on the screen, but just trust me, I'm going to start it on my watch. Battery's good. I've got 35% left on the watch. It should be able to stick around. 3, 2, 1. Listen for the door closing.
And Your Honor, the city would reiterate again that I believe it's appropriate for the jury to be able to review the video in.
We're going to see what happens. If they ask for it, we'll probably just send it back there.
I understand, Your Honor. I just, thank you. We should just hang out here.
That's what I'm thinking.
Let's just hang out here.
Ms. Rowe, do you have any comment on that?
No, I don't have anything.
My nightmare, of course, is if there's other things on the computer that.
It's purposely not. It's these laptops have been scrubbed for that purpose. That's why they do say trial use only.
So it's now, another thing, actually, we're on the record. It's 4:15. Just for the record, we're going to stay here. We may be here past 5.
Okay.
No.
If that's the case,
No.
I think security's been alerted, so the courtroom remains open.
Thank you, Your Honor.
Eliminate that issue. And then we'll see what happens.
So my
Sleep child care.
oops, I don't want that one. Okay, where's my timer? There's my stopwatch. Start. Now I'm a minute behind.
Pleasure.
I was going to say, I'm honored to have you opposing counsel at my very first trial.
Oh, yeah. As far as the opposing counsel goes, I'm pretty tame.
Well, I'd like to think so. Does that mean it gets worse?
Oh, it could. You could run into some real.
As far as
different
opposing counsel
personnel.
goes, I'm
That's fair. That's fair. I think I might have
So we're
already-
clear. We're still recording and on the record.
Oh, sorry.
Oh, but you didn't mention names. You're safe.
No.
Well, I was mentioning it now.
just to be clear, we're still recording. We're gonna just chill out here.
Also, they can hear a lot of our conversations if we're not careful.
Right. It's a good point.
Apparently,
I'm going to take.
I'm gonna wander in there and
This
just tell them
upstairs.
disregard.
Okay. Thank you, Corey.
We're quite cordial amongst each other. Let's see if we can get a super.
Oh, they've already requested.
First question is back. Here we come.
You know, I often tell my husband.
The password.
Oh, now they turned it off. They just barely brought a request back, and they. Okay, they've already requested the video. The can we see the video request just came in, which means they've already selected a foreman. Juror number 7's like now realize juror number 7. There's a juror number 7 who is the judge just talked to. That's a different juror number 7 than the current juror number 7, right? Than our juror number 7, the guy who is so excited to be here. They've gone and dropped the feet. So we're gonna watch and listen. So juror number 7, the original guy, his whole idea, what that was that he really wanted to be on the jury. Oh, they just went live on another one. Nope, it's just stuck. It's just stuck. Why? Default view. Refresh. No, they dropped to the feed. Okay, so here's what we have. Let me bring up. We need our timer. Box source box 1 will be 6. Box 2 will be, I think that's going to be 7. Oh, for now it's going to be 4. Show me super source and bring me this guy. Hang on. We need which connection? Objections final. No, not that one. No. It's not working. Let's see. Is this it? Not very good. This one? No. That's a little better. Let's work with this one. Box crop is going to be reset on this one. Bing boom. Oops, too far. Down a little bit down the top. Here's our jury timer. Now let's move it over tiny bit. There we go. There's our timer. Okay. So juror number 7, this is what I was telling you. 59 minutes till law and lumber. I know we're paying very close attention to that. Juror number 7, who is the guy who's like, I'm just jazzed to be on the show, right? I've been called to be on the jury service several times, 2 other times prior, and I never got picked. This is my time. I put in my time. I want to be there. He was the only person who wanted to be on the jury. As soon as he was positioned or selected, you have to think how many on the front row were selected. 1, 2. I think juror number 7 is now juror number 2 or juror number 3. So he is not the juror that got excluded from deliberation. So the guy who really wants to be there, he is deliberating. Yeah, we're already almost over the options. I think we had up to juror number 5. Put me in, coach. The guy's got to be the juror. We're waiting to see if they go live again. I'm waiting for the lasagna that was cooking and should be waiting for me. I'm wondering if Mrs. R.A. is going to take pity on me and bring me a plate of lukewarm lasagna, which I have no problem eating in front of you. Mama of 3 says, R.A., you need some overtime pay. I've had lots of breaks. We had like 2 lunches today. Plus we had a late start. And we're going to be done here very soon. I don't think we're going to push into Law and Lumber's time frame at all. Don't think that's going to happen. Mama of 3, thank you very much for the super chat. I appreciate your generosity. Maybe he gets to be 4-person 2. We're going to hang around. These things happen, and they happen fast. You realize that we heard as soon as we were leaving that, or as soon as they cut off the feed, that they had already requested to see the video. It's congealing for you now. Can it congeal on a plate in my studio? Is that an option? Yes, homemade Stouffer's lasagna. If you've ever had the Stouffer's brand of recipe, we make them and package them in this cool picture box and everything in a little tin, and then you stick in not the microwave, the oven. Let's go lasagna on stream. Woohoo! Poll on the jury time. We did a poll already. It was sort of split between blink and you'll miss it and 5 to 6 minutes. So I think all of us are a little bit outside of the winning numbers. Riddick watch must be how dads feel during labor. When is something going to happen? The new lawyer will get better. All the best to him. He will get better. He will do. He'll get more experience. Obviously, I think what he lacked the most in this one is knowing when to object and what to object to, and that comes with experience. That comes with time. I think on the defense side, the lawyer struggles with direct questioning of her own witness. So she's a defense attorney, and generally defense attorneys advise their clients not to testify. So that's she doesn't do very well on direct questions. She did better on cross. Unfortunately, she tried to lead on every question that she was asking on direct of her client, and instead of then rephrasing the question into an acceptable format, she moved on. And so they just burned through opportunities for this witness to present alternative versions of the events. And we already had 2 that don't match up. Okay, we have 2 events. We didn't get to see the video, so we don't see who it was closest to. But I would say that from the audio we could hear, I don't think the security guard got punched 3 times. It just didn't seem like it was happening. I'm fine with her speaking speed. I put myself in her shoes, and I would do terrible. So I'm fine that she took a long time. I didn't like that she chose to go over things that she really didn't need to go over in the closing. Yes, Robin, I think what happened, for those of you that are watching iOS devices, they just pushed out a new update on the phones and devices and all that, and I think it broke things. Hasey's Wildflower. I gave my dog a bath and did 2 loads of laundry. I mowed the lawn twice. Yes, it took so long. How long does it take the jury to watch the video? I think the whole video might be 5 minutes in length that he filmed, roughly. That was my guess. That's how long the video is. If it had been the smoking gun and shown the punch, I think they would have played it first. They would have led with that and then closed with that in closing. I don't think it shows anything. I don't think it really serves either person, other than the fact that the altercation shows that the language and the discussion was different. I have a hard time believing the balled up fist, Scott McLaren, only because I do agree after seeing the gentleman Rent-A-Cop that a stiff breeze might blow him over, and if there was a balled up fist, even at 50%, that might have taken him down. Is the video a security video or the defendant's? It's the defendant's video, and Donna, we think that we know they were confiscated. The video devices, both the GoPro he was wearing on his shoulder strap and his phone, were confiscated at the time of the arrest. And so they've been in the possession of the police department. They've probably been there the whole time. So I have not seen the original videos on his channel. He has posted other videos. He's done FOIA requests for the video from the dash cam, from the body cam, from the officers who responded, and he has that. Chris drank 4 beers during the closing statement, and I don't drink. So he's posted some of those, but we haven't seen the original video. I imagine after this trial he will get access to those videos again, because that will be returned to him. And I imagine the video will be posted on his channel eventually. Did I say Rent-A-Cop? Security guard is what I meant. I was thinking Paul Blart. I'm not planning on being on Rob's stream. I'm going to be a viewer, but I'm not going to be on the stream. Like he hasn't asked me to be there for any reason that I know of. About his record, yes, there may be other instances before the court involving various charges. Worst thing that can happen to him in this case, if he's found guilty by the jury and the judge hits him with the full weight and power of the law, is that he could serve up to 364 days in jail, so just 1 day short of a year, and then he could also have a $5,000 fine. That's worst case scenario, and that's pretty bad. A year in jail is no laughing matter. Did I watch Mr. Anderson last night? I watched most of it. I didn't get to hear the poop trail story. I heard the teaser for it, but I heard that he shared later on, maybe after that third glass of wine. And what about the stone crabs? I've never had stone crab. Is it as good as he says it is? These auditors start filming from before they enter the building. If this is a short video, then I would suspect editing on his part. They were confiscated from him on scene. I don't think he had a chance to edit. I think there's probably, here's what I'll say. There was a little clue that was given to us in the discussion by the defense attorney. She said, "Your Honor, I've been working on this. We started working on this over the weekend. It's possible this defendant might have been pro se and then switched to a public defender last week." There's just that possibility. I'm going to throw that out there. It might need a little bit of investigation. Fourth-degree assault is a gross misdemeanor conviction, or you can face up to a year in jail and $5,000 in fines. Yes, that's it. 364 days. It can't be full 365. It has to be less than a year. Stone crabs are awesome. Are those the ones that you just eat the claws? Like they pop the claws off and they grow back? Synth, we have blue crabs here, obviously, in North Carolina as well. Maryland blue crab, there is a YouTuber and a TikToker, I guess. This kid that looks like a little freckle-faced kid. He actually just got married. He's not a kid anymore. He just looks young, and he's got a boat. He goes out and traps crabs and harvests and has a YouTube channel. And he's the stingiest guy ever. He would never pay money for something that he could buy used. He'd never buy something new that he could buy used. And he'd never buy something used if he could build it out of trash himself. His name's Luke McFadden, and he has an amazing channel. He sells crabs on the side of the road, up in Maryland, I think. Anyway, I don't understand why the self-defense option was not allowed. I missed that part. Oh my goodness, Sergeant Mom. Why? This is in a motion in limine, okay? the prosecution says, Your Honor, we would like to move to make sure that at no time during this trial, the defense is able to raise a defense to the charge. Literally, you cannot say that this was self-defense. You cannot say that you hit him because he hit you first, which they say is what happened. And somewhere along the line, these attorneys or this individual, this defendant, if he was representing himself, said, yeah, I'm cool with that. Let's go ahead and say, yeah, we're not worried about self-defense. We're not going to even bring it up. It's not anything we even need to talk about. And so the judge ruled, okay, this motion in limine approved. You cannot bring up the self-defense aspect of this in trial. What other defense do you have if you admit there was an altercation? None. I don't know how the jury could say he's not guilty at this point, unless they just disregard at this point, if the jury disregards the jury instructions and finds him not guilty, okay, which I had hoped that they would do originally, but when I heard that this motion in limine was there, I don't have hope anymore. If they find him not guilty at this point, I believe the prosecution should move for a judgment notwithstanding verdict and ask the judge to overrule the jury, because according to the rules, I think that's the only option available to them. Oh, man. One claw. You're only supposed to move one claw. Snow crab is great. I prefer snow. Isn't like snow crab, like the numbers are like really low and they keep putting off the harvest for another year? Defense attorney forgot to file the motion. No. Maybe defense argued against it and the judge went in the state's favor. It's possible, but I can't. When the law literally says, and we're talking Washington state law, that a defense to assault charge is self-defense, and you have evidence or you have testimony, which they have, that the other guy started it. How any judge, this would be overturned in a heartbeat if a judge says, in spite of all that, I'm not going to allow you to bring up self-defense. They had to have agreed to it. This had to have been a serious mistake by the defense. Not self-defense, then property defense. Maybe they did that. Maybe they said, yeah, we're not going to go the self-defense route. We're going to say defense of property, which ended up being struck as well, where the judge would not include that instruction in the jury instructions. But hasn't the judge basically admitted he's not a fan of the defendant? The judge talked too much in this case. Methinks thou dost protest too much, Mr. Judge. You let it all known. You let it all known. There are many times where we have loved listening to a judge where he has presided over a case and see, still nothing happened. I haven't missed anything. Presided over a case and you're like, I wonder what the judge is thinking. Okay, I wonder. There's going to be a time, after this verdict comes in, where the judge gets to speak his mind, and we wait for that, right? And we sit there, and the judge is a blank slate. You've got the poker face going on. You're like, I think he's leaning this way, maybe leaning that way. And then when the verdict comes in, and he's unfettered, he's unshackled from these restrictions he has to operate on of being just a fair, caller of balls and strikes. Then they let loose. This judge did not wait. He made decisions based on evidence that was submitted, testimony that was submitted. He just determined which ones were valid and which ones wasn't. Said the evidence doesn't support this when there was evidence that was towards that. He already ruled on it, and wow. That shows. Yeah, it shows that he probably should have muzzled himself a little earlier. Jury is not back yet. They have been deliberating for about 19 minutes. It's like 1 minute. I'm assuming they took a minute to get to know each other, right? They played the get to know you game. They're like, hey, I met you at the water fountain this morning. I thought you were the witness, but really you're another juror. Hi, my name's juror number 7. Do you have the courthouse on one of those screens? Let me move it over. I have it on 7, so I'm watching this, right? Basically, all we're doing is hitting the refresh button to see when the live stream comes back, because they don't notify us. They don't think that anyone is interested in this case, which we are. We are. This is an important case. It might be a small case that, small peanuts. It's not a $261 million verdict on the line here, but it's an important case for the people that are involved, especially for the prosecutor. It's his first. If he loses this one against a lawyer who says, yeah, I'm a pretty easy lawyer to go against, yeah, don't say that, especially with your client right next to you. Okay. Maya judge made verdict appeal proof. This judge made it appeal rich. Yeah, there's some things. There's some things that might need to be addressed here. We're in verdict watch right now. We're in verdict watch. Let me go back to right here. Let me switch to this window and say box source is going to be 7. Cut. There we go. So there's our timer. Keep refreshing every couple seconds just to see. That's me. If it flashes, that's when I check again. And if you are watching as well, I'll try to stay up to date on chat in case something happens. Yeah, I'm not sleeping on the job. Yes, Adam Nuske, if you could automate the refresh page. I was just thinking. I told you. Let's go right here for a second. I've got this cool device over here with all the buttons. Right, it can switch and do a million different things, and it's got each of these set of lights is a page, and I think it has 78 different pages of options, and all of them change what happens on the screen. And I know what all of them do, but I don't use them all. There's a way that I can set this up so that a command in chat would trigger a request to this machine, and then I can automate a macro. It's a complex way of saying I could literally give you the control to do anything I do on this box, and that is risky. So I would never do that with something that could result in my channel getting taken away. But I could literally give you the ability to refresh a page or to do things like that. It just takes time, and I have very little of that. Mrs. R.A., I'm slowly fading away into oblivion. I'm starving. I'm slowly starving to death. So we don't need you. Pretty much I can make it so you could run the channel remotely yourself. The only key is I would have to start the... Oh, I missed the timer. Sorry. There we are. We're back. Okay. I don't want the power. Oh my goodness. This was an interesting little trial. I love these short trials. I like to peek into the courtrooms across the country and just see how things happen in places where nobody thinks we would be watching, right? Because literally nobody thought we'd be watching here. Even the judge doesn't think anyone's watching. That's why we ordered pizza. I was fading away too. Send in the Panda Express. Ooh, that's something I can get behind and in front of. I worry that a post I will make will be used in a future motion. Donna, this is great. This is great. And at the same time, we agree. We already saw in this trial that Ozzie Gardner, whose birthday it is today, was brought up in court because all for the crime of going to this man's YouTube page and saying, "Hey, saw you in court. Looks like interesting content. I'll give you a subscribe." And then the defendant saw the message on his phone on YouTube. Saw, somebody left a comment, and more people have left a similar message, by the way, in different places. And so he took that to his counsel, to his lawyer, and said, "Look, must be one of the jurors because they saw me in court and they subscribed. One of the jurors just subscribed to my YouTube channel." And that's not what happened. But I'm not going to call them and tell them. What is Panda Express? Oh, Lil Miss. Panda Express is heaven in a fast food joint building. It is the best fake Chinese food you will ever eat. It is so good. Try the honey walnut shrimp. Homeschool Ground Zero, we need a new Mrs. RA iPad only fund. What happened to the iPad? Mrs. RA? Did you tell Mrs. RA to bring you a mirror so you can watch yourself starve? I've got it on the big screen. I can see myself in 4 or 5 different windows. Chris, have a great one. You're probably not going to be able to stick around for Rob's Lawn Lumber tonight. We're going to redirect to that show when it starts. I've already set up the redirect. It's supposed to be in about 20 minutes. I was hoping that we would have a verdict by then, but we'll see. Yes, you can tell which iPad she has by which login she uses, Homeschool Ground Zero or Mrs. RA. KT says, I've never had Panda Express and I don't like seafood. Give me Italian, Mexican, or real Chinese food, or just let me cook. KT, seafood. I stood on the dock. I think it was in Larvik. It might have been in Oslo, Norway. Stood on the dock where a shrimp vessel had just come in. Oh, I smell lasagna.
Weather Watch read appropriately my sarcasm.
Weather Watch read your sarcasm appropriately. Oh, this Stouffer's looks delicious. It's so good. And yes, it is cold. I stood on the dock in Norway. The boat had just come in. They just made a huge harvest of shrimp. They right there, they steamed them right when they catch them, and then immediately flash freeze them. But they steamed them, and then they packaged them, and then flash freeze them. And the boat owner was friends of the family, and so they had packaged all their crates they could, and they had, I don't know, maybe 10, 15 pounds of leftover fresh jumbo shrimp that had just been caught, like literally just off the boat, freshly steamed, and they gave it to us. It's like, here, we're going to throw it out anyway. It's just extra shrimp. It's just not enough to make another package. So I ate the freshest shrimp you can possibly eat without going out on the boat and catching it yourself. And until I had to roll myself off the dock, and I was throwing shrimp to the seagulls. It was so delicious. Anyway, that's the seafood, my seafood story. That is good. Who throws out shrimp? It's a sin. Well, we just had like a bag of shrimp. We didn't have anywhere to put it. So we ate all we could and then had to throw the rest. A buck of lobster. Oh my goodness. That's an investment at that price. You could have kept them around and retired off that. All right, checking. Still nothing from the jury. That sounds not clean. No, it was clean. It was freshly caught shrimp, steamed, cooked, and then just given to us. We had like a if you go get vegetables in a plastic bag, it was one of those bags, just full of shrimp. And it was more durable than a vegetable bag. Those you breathe on and they just break. There's no such thing as extra shrimp. Anyway, I haven't seen the Boomers video yet. I know she's been cutting up some of those videos and posting little snippets, and they're great. They may find this guy innocent, or the excited guy is making them go through everything. I think we have a hung jury. Because honestly, I have a hard time with the prosecution. The lawyer, the new guy, his attitude about the whole exchange and the interaction, I didn't relate to that very well. I didn't connect to what he said. But if there's someone on the jury who did, there could be somebody who would definitely feel that that this guy was in the wrong from the get-go. Okay, and I believe he's wrong morally. I think he may have legal grounds for filming. He's not being charged for filming, though. The fight, I think he probably is guilty of that. I don't think that a reasonable person would recognize that somebody trying to block your camera is a reason to deck him in the face. So I don't know, but I'm thinking they might find him guilty. That's where I'm leaning. Did we already vote on that? I think 2/3 of us said guilty. This is so good. It's cold. It's cold, but it's so good. Been deliberating for half an hour now. Sheila says, I'd change my vote now. I'm done. It's been too long. I have a confession, Weather Watch. I love spicy maple bourbon pickles. As a matter of fact, I ate half a jar of them, which is about 12 ounces worth, during lunch, just out of the jar with a fork. I don't like them with other foods that I normally eat pickles with. They're a food I almost have to eat by itself. Let's see, Missy Dee Moo. I just started watching after waking up. Last I saw was halfway through jury selection. Oh, Missy, boy, did you miss some fun stuff. Did the guy who was not selected for jury 7 or 8 times get picked in the end? Yes, he did. He was juror number 7. He's deliberating right now. I'm concerned that you guys can hear me chew, because when I have these headphones on, I can hear myself chew. I would be mortified if that were the case. So please all say no, we couldn't hear that. I will say we cannot listen to his YouTube channel because the Mr. Farley, he put music behind the video, and I don't have rights to the music, so I could get struck from that. and it's possible with being another creator, just using their content could be problematic for the channel. If he sees an opportunity to issue a strike against me. Where's the milk? Oh, I know. I realize. But I'm just very glad you brought me lasagna. I'm not going to push it. I would love some milk, though. Let's see. Jury may consider that security guard frightened auditor by backing him into the corner and grabbing him, thus causing the auditor to instinctively push the guard away. Irresistible urge? It's not in the jury instructions, so they might come to that conclusion, but they're told to just follow the instructions they received. When are we going to break for lunch? Perfect timing on that. It was a little quiet on my end, and that's my fault. I don't want to get struck by him. No, I imagine that would not be a fun experience. It would not be somebody I could call up and work through as readily as I like.
I'm not a camel.
Yes, I'm quite thirsty. I'm very, very thirsty. I need red wine. I actually don't drink alcohol, so I don't need that. Remember, the show's called Recovery Addict, Virginia Little. You're starting to try to get me to drink. But assault has to be intentional. Elizabeth, you're still there. Elizabeth, we're waiting for the verdict to come back. We thought it would be done by now, but
Bring the jury.
Yeah, seriously, bring the jury. It was nice to see Mr. Judge Newman today. For those that watched, the door's opening. Should I look and see? Yeah. It is milk, which is my favorite beverage. I think I've died and gone to heaven. Eating lasagna, hanging out with some good friends, family, bringing me food. This is wonderful. All right. No, it's cold milk for sure. It's cold milk. That was my son that brought that to me. Thank you very much, son. Milk is cat beer. I heard milk is bad for cats. Is that true? Because I have not been feeding my cat milk. Mostly I just feed it fresh turkey.
Have them send someone with more experience.
That was all the kids, says Mrs. R.A. Cats are lactose intolerant. All right. I do have a cat question for those of you who can help me on the cat issue. My cat, first of all, it does not know how to meow properly. It's sort of a growl. It's like a meow. It's like a mean meow. Is that
correct?
That's correct. That was a very good attempt to mimic its sound. It was like a meow type thing. It's not like the soft meow you expect. It's just not the little pure tone behind it. It's more of like a half growl and like I'm doing this under duress type thing. So it can't meow very well. But it will do that when you first come out, and then it will, walk. It will try to trip you, as I guess that's a normal thing that cats do.
I'm not a cat.
I'm not a cat. The meow is very demanding. It's almost a hostile meow.
When are we going to break for lunch, Judge?
We've had lunch twice already. So it does this meow, and then it tries to trip you as you walk over to feed it. And you feed it its yummy kibbles and bits. I don't even know what brand of cat food we're feeding it. We've switched. We've done 3 different brands so far, trying to find out which one it likes best. And it will do this thing where it runs to the bowl and you pour it in, and it sniffs, and then it turns and walks away. Right? It was just barely begging for food. It would have jumped and clawed it out of my hand if I was holding turkey. But it runs to the food bowl, sniffs it, and turns and walks away. And then I'll go and I'll sit on the swing on the porch or something, and it will come over and jump on my lap and whatever, and it will wait and it will wait and look around and jump around and claw my hands and stuff like that, and look at me accusatorily, and then we'll get down and we'll go in and eat food. You want soft food? Well, the humidity is so high here in North Carolina that if you have hard food and you leave it out for more than like 10 minutes, it becomes soft food. Does that not count? My question is, why does the cat ignore the food and then go eat it?
Have them send someone with more experience.
Maybe it's the brand. Do you guys, for those whose cats love the food, is it soft, mostly wet food, not dry food? He's waiting for the turkey. Kind of, sort of, in a way. I think you might have something there. Although cows, the young cows will nurse for as long as they can get away with it. Okay, so now we need to do a new poll because we're now 5 minutes away from Rob's official start time, and I want to see if you guys would like to stay here, or if you'd just like me to go live when the verdict comes in.
When are we going to break for lunch, Judge?
Okay, I think. Let's see, Rob will be 15 to 30 minutes late. Should we go join Rob or stay here until we get a verdict? Top option is Rob, here we come. The bottom is stay. I have nowhere to go. Rob will be late. Rob's going to have some good stuff tonight. I am super excited to watch. I'm super excited to watch. Why can't we just have the verdict like right now? Amber, do you want to call the court really quickly and see if they can arrange that? I have one complaint about Stouffer's lasagna. We buy our Stouffer's lasagna at Sam's Club, right? The tray. It's labeled wrong. It says family size when it should say single serving size. That's my one complaint. I understand why Rob is late. If you guys understood, his schedule is crazy. He runs and works during the day, and then commutes home, and then he'll schedule. He's like, well, work ends at 7:40, and if traffic's good, I can get home in 15 minutes. That'll give me 5 minutes to come in the door, turn on the computer, put up the live stream, and then that's when he makes his start time. And that's how close he cuts it. This guy is like, he literally, there's no time for a break. He comes in, he just sits down, goes live. He's putting in all the hours. Much respect. We have time, but the jury is taking their time. I'm not sure how they're watching this over and over.
talking about stuff that is not relevant.
I need the party size. Where can I get the party size? Do you have to special order that? I thought Sam's Club would be like the biggest version. That's like when I go to Chick-fil-A and you order those little nuggets, those Chick-fil-A little nuggets, which are delicious, by the way, especially with their Chick-fil-A sauce. You go and they order and they're like, "What size would you like?" And I'm like, "Well, I'd like the catering tray size." That's how much I would like. I got spoiled on that when I was filming for basketball games for the NCAA and stuff, because they'd bring catering for the press. So we go down and we get all the press food. It was delicious. Okay. 45 minutes of deliberation. This should be enough time. I think we've got to hold out. Rob is covering Kowalski, juror number 1 response. And let me just tell you, Rob has inside scoop. Rob has inside scoop. Good stuff. A widget. We did it once on accident. And we filed a complaint with the company. No, just kidding. We weren't a big fan. We weren't a fan of the veggie. It wasn't quite the same.
I was kicked back, taking it easy.
Yeah, I think that was going to be the big reveal tonight, but Mr. Anderson let it out on Megan's show last night that they had just met during the week. Okay, it is 8 o'clock. Here's why I think we should actually bail a little bit. This is the reason, and we've got a few minutes before Rob starts. I understand, but if we have a holdout, this could push into Wednesday morning. Okay, the jury has not been deliberating very long. And I would be very surprised that in 45 minutes, in less than an hour, a jury has decided, a juror who feels strongly one direction has decided to change their mind and flip. I don't think that's a decision they can come to very quickly. When they come back the next day, I think they'll be able to think it over a little bit, maybe think through other people's opinions and reasons for voting. So I think we might be back tomorrow morning. But that being said, even if Rob's live, I will go live and do a quick little hit with this video if it comes back tonight. Is that fair? If it comes back tonight, I'll go ahead. We'll bring the verdict then, and then we'll probably recap it tomorrow morning for those that weren't able to watch it live. Is that a fair compromise where everyone can agree on? And I also, half of me thinks that as soon as I say yes, we're going to end the live stream, they're gonna come in with the verdict, and I would have to do something like, no, it's not gonna happen. I don't think, not tonight. All right. So here's what we're gonna do. We're gonna bail. I've already got a live stream rerouted to Rob's channel. I think he's gonna be live any moment now. He's just a couple minutes late as usual, but that's all right. We've had an amazing trial. It's been quite interesting. The jury's deliberated for 49 minutes roughly. And Adam, the entire time, has kept the internet running, which is just amazing. Thank you. Today, thank you so much to my amazing mods who keep everything happy and copacetic in here. Appreciate you, every one of you. Also, thanks to you, the new people who joined us today. Thanks for joining us. Thanks for becoming part of this fun little community where we like to be respectful and watch interesting trials. So hope you will join us again. Thank you for subscribing. If you did, please subscribe. We'd like you to join us that way as well. That way you can chat with us and we can learn your opinions. Giving them a chance. I'm refreshing. Still not there. Alternate juror still on standby for sure. we're going to go live again with the verdict. If it comes in tonight, I'll go live and do a quick little hit. It might be a little bit late, but it'll be short. Well, I expect the entire thing to maybe be 10, 15 minutes. So we'll watch for that. And obviously, if you see the verdict come in on the channel, if you happen to be staying up and clicking refresh like I am, and you see it before me, send me a buzz on the burner phone, let me know, and we'll try to go live right away. Other than that, we're going to be over on Rob's channel watching him share some more information about what he's learned and go over and give us his take on the response. So thank you all very much tonight. When you go home, please hug the people you love, smile at someone to make their day just a little bit better, and please stay safe till we go live again, which might be later tonight for a 4th time. So thanks. We're going to portal right now over to Rob's channel. We'll see you guys later. Bye.